commissaire, on m'indique de commencer, puis j'ai le problème. OK. J'y vais?
Christian? Can you hear us?
Oui, en effet.
Okay.
I can hear you.
Okay.
Order à l'ordre. The Public Order Emergency Commission is now in session. La commission sur l'état d'urgence est maintenant ouverte.
Okay. Bonjour.
Good morning. Welcome to this fourth day of our session on policy.
Policy Day. Today we're dealing with police-government relations. Nous traitons des.
We'll be dealing with relations between police and government. So we have an excellent panel. There are some people I've heard earlier this week and others who are new to the Commission.
I'll turn it over to Professor Baker to introduce our panelists.
Thank you, Commissioner, and good morning, everyone. My name is Dennis Baker, and I'm an Associate Professor of Political Science and Acting Director of the Criminal Justice Programs at the University of Guelph. It is my honor to be moderating this roundtable this morning. We have an impressive array of experts here, and I'm going to introduce them briefly, going around the table. Malcolm Thorburn is Professor of Law and Associate Dean Graduate Studies at the University of Toronto. Next to him is Professor Michael Kempra, who is an Associate Professor of Criminology at the University of Ottawa. Kate Pudister is Associate Professor of Political Science in the Department of Political Science at the University of Guelph. Ryan Teschner is Executive Director and Chief of Staff of the Toronto Police Services Board. And James Raymer is the Chief of the Toronto Police Service. And joining us online is Christian Leprecht, who is the class of 1965 Distinguished Professor of Leadership at the Royal Military College and Director of the Institute for Intergovernmental Relations at Queen's University. So our topic here this morning is the relationship between police and governments. As Professor Pudister and I can attest, having taught many Guelph students over the years in a class called Governing Criminal Justice, this is a relationship that is fraught with challenges and does not lend itself to easy answers. We know that neither extreme is appealing. The idea of government-directed police force, where the police become an arm of the government of the day, is repugnant to our commitment to the rule of law and threatens our democratic right to express our displeasure with the government. The other extreme, fully independent police, risks allowing those police services to be a force unto themselves, disconnected from civilian control and legitimate democratic authority. The relationship must be somewhere in the middle. But that middle, as my students know and Professor Pudister's students know, is sharply contested and often difficult to operationalize. So today we're going to talk in some detail about the capacity of governments to direct police, the sharing of information, and the relationships between different police services and the multiple levels of government. My hope, Commissioner, is that even if we cannot provide you with definitive answers today, we can at least assist you by outlining the contours of the debate and where some of the reasonable disagreements may lie. With that, I'm going to turn the session over to our panelists for opening statements. I've asked each panelist to speak for about 5 minutes, introducing their approach to the topic, and then we're going to have rounds of questions focused on different aspects of the relationship. One final reminder to everyone on the panel, speak slowly, something I'm going to have to struggle with, and always identify yourself when speaking for the benefit of our translators and transcribers. So Professor Michael Kempa, I have you in alphabetical order, so you are up first.
Great. Thank you very much for including me, Commissioner. And as you know, the issue of political engagement and civilian oversight engagement with policing has plagued the Canadian system since the MacDonald Report in 1981. It's over 50 years, but I have every confidence that we will resolve these issues here today and through the work that you'll do on the Commission after all this time. I approach policing basically as a window into politics and political economy, which is simply to say the way that a society sets up its policing system divides responsibilities between public policing authorities, private policing authorities, and civil or volunteer policing authorities, says a lot about their broader views of the proper role of the state generally, what a market is and what its purpose is, who it serves, what a civil society is and what a civil society can contribute to a society, to the broader political economic context, how to define citizenship and how rights of citizens are to be institutionalized, including who is included and sometimes accidentally excluded from these regimes of rights. So that's at the theoretical level. At a practical level, I'm simply interested in who makes the decisions around policing policies, operations, and the exercise of policing power. And my general concern is that all three of these things are as democratic as possible, which means as close to community as possible, as reflective of community values and needs as possible, balanced by the need for the exercise of policing power as a form of legal power to be independent and democratically accountable. Now, the way that those things come together in different circumstances will vary. The answer will not always be the same depending on what type of policing powers we're talking about and what circumstances. But generally, by interrogating those questions, you get a good window into democratic theory and political economic theory. Thank you.
Thank you, Professor Kempa. So next up is Professor Luprecht, who's on Zoom.
Yeah, so if we frame the problem here, donc merci de l'invitation aujourd'hui.
Thank you for the invitation.
Modest but tenacious protest in Ottawa, and the system comes under moderate strain and is unable to come together to achieve strategic effect. I mean, we get more people in Kingston for homecoming than we did in Ottawa for the convoy. So let's think about that. So Police Services Acts call for adequate and effective policing. What does that mean? It means policing the response to the needs, values, and expectations of the local community. On the other hand, police swear an oath to protect life, property, and prevent crime. So the question for police is, what's the best way to keep the public safe? And you can already see emerging here the fundamental problem, which is the delta between public expectations on the one hand, as well as the quantity and the quality of policing. And I would say that delta in Canada continues to grow. And so we can use the Ottawa convoy as a critical case study and a laboratory of experimentation of generally what ails the national security system, because what we have here is a fundamental failure of the entire intelligence, law enforcement, and national security system. So police resources are always oversubscribed, even in normal times, and so they'll follow risk. And so that means that police planning, decision-making, and action depends on the intelligence cycle. Planning and direction, collection, processing, analysis, and production, dissemination. We had multiple agencies generating those: CSIS, the RCMP, Criminal Intelligence Service of Ontario, OPP, OPS, open source through media, and it seems we never were able to come together to actually produce a coherent picture. Just think about who would let all these trucks downtown after the World Trade Center bombing in 1990 and the Oklahoma City bombing in 1998. So there's four, I think, key elements here. The issues with regards to the chief in Ottawa, I think, are more symptomatic of broadly issues in Canadian policing when it comes to police leadership, police management, police institutional culture, and policing posture. Issues with regards to the board are emblematic of challenges of police governance more broadly, but also what happens when we don't have adequate police governance. We have interagency issues of, and in particular, police didn't ever appear to have an appreciation of the totality of circumstances that affected this situation. And we have intergovernmental issues where the premier, the prime minister, and the mayor should have stood together with their chief law enforcement officers, and instead we got squabbling among them. All this in the capital of a G7 country. So the system was unprepared. And so I think what we get here, this was more symptomatic of a number of broader issues. One is we have good incident response among law enforcement in Canada. We have difficulty with sustainment. in particular on issues of intelligence, planning, and logistics that a medium-sized police service, such as the Auto Police Services, cannot simply be expected to have for national protest. That's where we need national and to some extent provincial agencies to come in. Where was the RCMP surge capacity? We're always told we have this national police force of 17,000 people, so we can surge in times of a crisis. Between A Division, C Division, O Division, and headquarters, we have well over 2,500 people that could have simply gotten in their cars that are not on frontline patrol. Where were they? We had a loss of trust and confidence by the public that caused politicians to meddle. We had issues of outdated policy, which are governance issues. There's a broader debate about what constitutes national security. We have this very realist and traditional approach that I think does not do well in coping with economic security and political stability, issues of hate crime, ideologically motivated violent extremism, and so forth. 6, we have a reactive national security posture in preserving national security when we need a proactive and intelligence-driven one, where federal agencies have to have a firm and clear understanding of their mandate and on issues so that they can clearly advise local agencies. And I'd say there's a general vulnerability that was created in Ottawa where this vulnerability to public safety and national security then create multidimensional issues of destabilizing Canada and its democratic institutions more broadly. The conclusion is that the Emergencies Act shouldn't and wouldn't have been needed had the system performed well to achieve strategic effect. The fact that the Emergencies Act was invoked is an indictment of the system and its inability to perform for Canadians, for the government, and for local citizens in Ottawa.
Thank you, Professor Lebrecht. I'm going to remind the panel to please try and speak slowly for the benefit of our transcribers and translators. Professor Pudister.
Thank you. Good morning. My name is Kate Pudister, and I'm an associate professor in the Department of Political Science at the University of Guelph, and I'm pleased to be here with you today. My research and teaching are in the areas of law and politics and criminal justice policy. With colleagues, I have researched and written on several aspects of police governance and accountability. This work includes a study of the RCMP's Mr. Big undercover technique as a test for various types of police oversight for a routine but covert policing operation. My current research examines civilian police oversight in Canada with a focus on Ontario in particular. I've written on the investigation, prosecution, and sentencing of police officers in Ontario and the work of the Ontario Special Investigations Unit as a method of police oversight and accountability. My work demonstrates the very complex and challenging nature of these cases for the justice system. Through my work, I try to highlight the importance of public legitimacy and police oversight and the various sites of accountability for police. My research has shown that for some matters of policing, parliamentarians, responsible ministers, and police oversight agencies either show little interest or are incapable of regulating police conduct in an ongoing basis or in approaches that are more systematic and comprehensive in nature. To this end, there are examples of elected officials in Canada being unwilling to take on difficult matters of police policy and operations, instead choosing to rely on a notion of police independence that is too expansive and unhelpful for effective democratic governance of policing. I see my role on this panel to think about connections to police accountability and civilian oversight with respect to police-government relations. In thinking about this topic, we are often presented with discussions about the importance of police independence and the dangers if police independence is not taken seriously in a democracy. Too much government direction of the police and overreach presents a problem for the rule of law, but too much police independence raises issues for democratic accountability and other problems for the rule of law. This conversation usually turns to distinctions between policy, something that is the rightful domain of governments and police service boards, compared to operations, something that is the rightful domain of police themselves. I know that we'll discuss these issues further this morning, but my perspective is that this distinction and an attempt to draw a clear line between the two does a disservice. This focusing on the distinction between policy and that of operations leaves out critical conversations about the role of the public through civilian oversight and the importance of other sites of accountability, such as the courts, the media, and inquiries like the present. Importantly, this formulation allows governments to shirk responsibilities with respect to policing, perhaps as a method of political strategy, instead of having a more nuanced discussion about the respective roles of each and how this might change based on the nature of policing that is required, considering the wide scope of responsibilities of the police. Police in Canada are tasked with a wide range of responsibilities as laid out in legislation: crime prevention, law enforcement, assistance to victims, public order maintenance, and emergency response. Each comprise different and occasionally competing demands. When thinking about the governance of the police, there's value in having a nuanced conversation about these different roles and how police independence or operational responsibility might take on a different meaning and importance. Perhaps there's a greater role for government oversight when responding to issues of public order policing, compared to the core responsibilities of the police to investigate a particular person or persons and to lay charges. My perspective is that there's value in establishing through public policy the responsibilities of both government and the police, to articulate the accountability mechanisms, to define procedures of communication, information sharing and direction, and so we can identify cases of undue influence if they deviate from these guides. Enacting policy and legislative guidelines can promote openness by allowing for the setting of policy priorities, debating the direction of those priorities, and for policy evaluation, all of which can be aimed at ensuring democratic values and principles are alive and well in Canadian policing and police policy. Clear rules can articulate lines of accountability and oversight, which can not only guide police-government relations in the future, but it can also further public confidence. And with that in mind, I look forward to our discussions this morning.
Thank you, Professor Pedister. I'll call on Chief Raymer.
Good morning. Let me first thank you, Mr. Commissioner, for inviting me to participate in this very important exercise. I am a lifelong practitioner, having devoted my working life to policing, public safety, and crime prevention. I hope that I can provide some insight into how theory is applied. The title of this session is Police-Government Relations. The essence of the discussions is how do we construct and reinforce public institutions that preserve and promote democracy. I firmly believe that democracy is more than just voting. Many institutions promote democracy and the balancing of rights. Some institutions, however, can promote democracy or detract from it depending on how they are administered. Policing is one such institution. In my view, we must be careful to avoid adopting strategies aimed at remedying a particular problem that tend to undermine a system that, generally speaking, works well in this province and across Canada. A system of policing that is independent of political interference is a system to be protected and nurtured. It is a key aspect of democracy. It must, of course, be accountable to the people, and the leadership must be responsive to the people and ensure that the rule of law is maintained. The police cannot be seen as a tool to be used by any particular government, but must be seen to be operating on the basis of democratic principles. The leadership in policing need to be experienced, trained, empathetic, and humble in order to be effective. Long ago, in response to political interference in Toronto, born of divisions transplanted from abroad, the provincial government created a police commission designed to protect the police service from actual and perceived interference. That system has evolved into the Police Services Board system we have today. That system has evolved and matured to ensure that politics does not intrude into operations, but that the direction of policing is responsive to the legitimate needs and expectations of the people. I am of the view that while I accept there is room for improvement in the system we have developed in Toronto, we are currently positioned as well as we ever have been to ensure responsive, accountable, and independent policing for the people who depend on us. The service embraces the role of the board. We do all we can to ensure they have the information and assistance they need from us to fulfill their role, which is often stated to be ensuring adequate and effective policing. I am sure Mr. Teschner will unpack that concept in the course of our time together, but for me, it includes providing the service with policy direction that informs our operations. It is a relationship that recognizes that the board can and should collaborate with the service and can do so in a way that augments its oversight ability and does not detract from it. The service has also matured, and we realize that the board can provide unique civilian perspectives that actually enhance our operations. So we have policy and operational discussions frequently, and each of us are the better for it. However, a key to those discussions is that we each honor the other's roles. The board also plays a key role for the police in being the contact point with government. The board is, in that respect, another key democratic institution. The board allows the government to learn of some aspects of policing and even questions operations with the board. Thus, the government will not be seen as directing operations or attempting to do so. The board also assists in resourcing in concert with the service and assists the service in speaking to government in terms of powers and authorities that would assist the police in carrying out their duties. That encapsulates my view on police-government relations, and I look forward as well to today's discussion. Thank you.
Thank you, Chief Raymer. Mr. Teschner?
Thank you, Professor Baker. Good morning, Mr. Commissioner. Bonjour. I have spent over a decade focused intensely on police-government relations, first as a lawyer, then as lead counsel to Judge Morden for the G20 review, and then now a front row seat as Executive Director and Chief of Staff to Canada's largest municipal police services board. And so I have some reflections. I approach this as a discussion of principle, and there are three that I think animate the approach to effective, appropriate, well-balanced police-government relations in Canada. The first is an acceptance that we must keep politics out of policing. Law enforcement decisions, in their core fashion, should not be made or directed by those in elected office. Police officers have common law authority independent of government and must undertake their core law enforcement functions separate from government direction in order to maintain the rule of law. But we have to be careful not to lean too heavily into creating a bubble of immunity that prevents governance and oversight of police in terms of their plans, actions or inactions, or otherwise impedes the flow of information essential for governance and oversight to function. The second principle is that we need governance and oversight in some form. Policing requires, in my view, some form of independent governance that is forward-looking, that is prospective, and that embeds due respect for community norms. We need this to maintain the public approval required for democratic community policing systems to function. It helps ensure that the public's accepted values and norms, as many of the other panelists have mentioned in their intros, guide the delivery of policing. And it puts in place the policy infrastructure that sets the rules and limits within which specific law enforcement decisions will be made and actions taken. We also need independent oversight, after the fact accountability processes that examine decisions or acts once they have already occurred and help us learn from them. Third principle is that we need an intermediary who mediates and sometimes arbitrates interests. There must be a way to, without government being the decision maker improperly, translate public values and expectations into a framework within which policing services will be delivered. Someone must balance competing interests of different constituencies, a diverse public, police leadership, elected officials, oversight actors, interest groups, but ultimately make the policy decisions, set the priorities and objectives from which police actions flow. There are a few other key points I'm sure I'll expand on today. One is that the ability of independent governance and oversight bodies to function and fulfill their important statutory mandate requires a healthy information exchange, and that is not the same as impermissible direction of the police. The second is the need to balance the concepts of independence and accountability in a way that avoids political interference, but avoids political shirking of responsibility. And the third is that community connection that the boards and commissions across this country provide help ensure that a community needs and their expectations as they evolve are matched, that there's a feedback loop so that policing evolves alongside. Very quickly, I'll put this by way of analogy. I look at the role of police boards and commissions the way that I look at building a house. You have an architect and you have a general contractor. Police boards are the architects. They have a vision, they develop the blueprints, they set the plan. Police chiefs and police services are the general contractors. They are the experts. They come in and they mobilize the trades, the resources, the equipment, the tools in order to bring that plan to life. Each have an important role. But for anyone who has built a home, renovated a home, you know that you have to respect the roles of each in order for the system to function properly. And I look forward to expanding on that more today. Thank you.
Thank you, Mr. Teschner. Professor Thorburn?
Thank you. Bonjour et merci, Monsieur le Commissaire, pour l'invitation à participer aujourd'hui.
Thank you, Mr. Commissioner, for this invitation. My name is Malcolm Thorburn. I'm a professor at the Faculty of Law at University of Toronto. I'm also the research chair for innovation. I teach criminal law and evidence law, and I do research on police and the police in constitutional order in Canada from a theoretical point of view, but also practically. I will give my presentation in English today, but I'll be very happy to answer your questions in the two official languages.
By outlining what I take to be the main concerns that should structure our thinking about police-government relations. I know that many of my fellow panelists are criminologists, police officers, political scientists who have already brought enormous insight into the policy considerations that pull us toward one arrangement or another. I'm going to focus my own thoughts on some of the legal considerations, common law doctrines, constitutional principles, and so on, that I believe should structure our thinking on this topic. And the central idea I want to put forward is one that we've already heard mentioned here, that in Canada, I believe we have for too long had a rather vague and sometimes often overblown conception of police independence from government. As a matter of common law doctrine and of constitutional principle, made clear in many places, our Supreme Court's decision in '99 in Campbell, for example, it is clear that the police should be fully independent of the government, police services boards, ministers, whoever, while engaged in criminal investigation, commencing or ending investigations, laying charges, and the like. That much, I think, is clear as a matter of law, and I think I would agree as a matter of policy. And that is because in these situations, when the police are targeting specific individuals for the attention of the criminal justice system, full independence is essential to the integrity of their operations. Without it, there is a significant danger that the criminal justice system might become a tool of the government of the day. As with other parts of the criminal justice system, impartiality is crucial to its legitimacy. But outside the context of criminal investigation, there is no good reason, I think, to think that the police should be fully independent of government. Indeed, there are plenty of good reasons to think that they should not. So the police have wide discretion, considerable coercive power over increasingly wide variety of different areas, well beyond the scope of criminal investigations. It is, I think, intolerable in a democracy that all that power and discretion should be exercised without significant democratic accountability and input. When making decisions about crowd control at large-scale protests, for example, there are important public policy considerations at play. The possibility of economic life for the surrounding community, access to education, healthcare, other important services, sometimes matters of international trade, and so on, that must play a part in decision-making about how to police those protests. So we've seen in a number of important judicial reports on policing, from Justice Morden about the G20, Justice Linden on Ipperwash and others, urging a more pragmatic allocation of decision-making power and certainly an increasing flow of information over an array of police activities. Unfortunately, though, many politicians, solicitors general, police services boards, others, have assumed that police independence should cover much more than just the investigation of crime. What's more, of course, there is legislative language in Ontario, Section 31(4) of the Police Services Act, that draws this sharp distinction between operational decisions with respect to day-to-day operations and policy matters. But I believe that broader understanding of police independence undermines the accountability and ultimately the democratic legitimacy of policing outside the area of criminal investigation. So how then should we demarcate areas where the police should maintain strict independence from areas where more government input is appropriate? Well, first, I think we should continue to ensure full police independence over criminal investigations, and we should do so in clear, unambiguous statutory language. But outside that area of criminal investigation, we should make clear, also in clear statutory language, that police independence is not a bar to the free flow of information to and from police services and boards, and to some direction from government. Making clear that these other areas of police operations are not subject to strict police independence will allow for a proper flow of information between police services and government. As Justice Morden pointed out 10 years ago in his report on policing the G20 summit, police services boards cannot perform their oversight function if they lack adequate information about the police services operations. And further, we should allow for more guidance and input from government in crafting policies, priorities, and objectives in these other policing areas. As we have seen at virtually every large-scale protest in Canada over many years, including earlier this year, the police lacked clear guidance about how to regulate those protests. The police need more and clearer legal guidance about how to deal with these large-scale protests and other critical points, as they're sometimes put. That said, I wish to acknowledge that it is very important that political guidance and the sharing and information should not become a road into partisan capture of policing. The police mission must be one that is subject to democratic oversight, accountability, and input, but not to become the servants of the government of the day. So, to that end, I think we ought first to make any government input clear, publicly accessible, and in writing, such that that guidance can be subject to democratic accountability. Also, that where possible, organizations such as police service boards can act as intermediaries between elected officials and police departments. I look forward to the discussion later this morning. Thank you very much.
Thank you, everybody. It's tempting just to let you all ask questions of each other right now, but we're going to have slightly more structure than that. Our first set of questions relates to directions from police to police from government. And we've already heard a little bit about that in many of the statements. So the questions we're going to specifically look at are, what direction may police boards and governments legitimately provide to police? And in particular, I know this commission is interested in whether, specifically, may governments provide directions establishing priorities for which regions, police resources should be deployed during a major event that impacts multiple locations. So that question is before us. What decisions in relations to managing protests should be made by police alone? Is the policy operations distinction that we've already heard about meaningful, and can it be usefully applied? So with that, I'm going to ask Professor Kempa to start us off.
Thank you. So, Commissioner, I've made a real commitment to our panel chair to be as practical as possible in my discussion today and to really try to avoid getting bogged down in the theoretical weeds that have accumulated over the last 50 years on this particular topic. The issue of whether or not the policy operations distinction is even useful in terms of discussing what types of questions political overseers or civilian overseers can ask of police organizations, what types of direction these same bodies can give police, is a good one. And I think the metaphor that's come up over and over again over the course of this commission is the separation of church and state, where the idea was that political direction or questioning should definitely not cross some sort of a threshold which was understood as church throughout the commission. But the opinions as to what exactly the line was within the church were mixed from the evidence that you heard here. There were some that would have given you the idea that political overseers or civilian overseers should not even put a toe into the church, for example. And there were others who said, no, political overseers can come in and ask questions, but certainly not even make a suggestion or tell us what to do on any operational level whatsoever. So what I would suggest when we go through the history of the reports looking at these matters, at the level of civilian oversight bodies, police services boards, Linden is the report that is most helpful for us. The Morden report is the most helpful for us. At the provincial level of political direction, it's Linden. And at the federal level, of course, it's the McDonald report and the more recent Brown report looking into these matters with the RCMP. So what I would suggest, rather than thinking of church and there's really no role for the state or political or civilian overseers inside the church, in fact, they're fully welcome in. They can ask questions about operations. They can give advice about operations at a general level, but they ought not to be allowed into the confessional, which is to do with the exercise of police powers specifically. So my answer to the question on whether that dichotomy is useful is I would say yes, but I actually prefer to think in terms of a trichotomy that just makes it a little bit more specific. So on the one hand, we do have policies, which is the domain of either civilian oversight bodies where they exist or the political ministers responsible, if we're talking about the federal level of the RCMP. Then there are plans, which can be conceived as the more general level of operations, where there is a legitimate role for any of these bodies to ask questions, demand answers to these questions, offer even suggestions about overall plans, but in the end, it is the final decision of the chief whether or not those suggestions will be executed at the level of plans on the ground. And then finally, powers. Powers, the exercise of powers is the most specific level of operations. This is the confessional, and this is where there is absolutely no role for civilian oversight bodies or for the political directors of policing, the ministers responsible. So where we think about some of your more specific questions, for example, what directions may police boards and governments legitimately provide to police? Well, obviously they're setting policies. But in terms of an operation like something for a major protest event, there is no precise legal definition for what type of advice a board would give a chief of police on how to generally go about strategizing to deal with a mass protest. This comes from the Linden report as well. Rather, there needs to be a deliberative discussion process in place where these issues would be worked out. I know that very many would say it's difficult to define these things in law, and it's important to leave some space for your professionals to have room to work these things out amongst themselves within a framework. So I'm suggesting this is a general but specific enough framework, policy, plans, and powers, that within plans, there's the space for the participants to negotiate where the board would offer advice and where they would stop. Some of this would be common sense, for example. The board's members are typically not police professionals, so they don't have experience in deciding exactly where you would send contingents of officers on particular corners and so forth, nor would they even really have very many questions about those issues at that level for their chief. They would have questions about whether certain laws might be used as tools to be enforced, but not when and where those laws would be enforced or not. The timing and the ultimate decision to use those authorities would be for the police and the police alone. What types of information can boards or political masters ask for? On matters of operations, they should be asking questions about planning before and after plans are designed and executed. So before, again, the types of questions that a common sense approach within this framework would dictate would basically be what any good board of management would be asking. Chief, how did you come up with this particular approach? Were other alternatives considered? The board may have no idea what other alternatives would look like, but a good board of management makes sure that their executive officer in whatever branch has considered alternatives, for example. Is there any evidence to suggest that this would be a better approach than something else? The chief might simply reply, yes, this was a model that was deployed to good effect in protests in Seattle. We feel that there's some similarities, and that's why we're following this model here. It's a standard deliberative type approach in that sense. On your next set of questions here, we have a question, may governments provide directions establishing priorities for which regions, for example, police resources should be deployed to during a major event that impacts multiple locations? So the simple answer to that is yes, absolutely, and that's by Linden, where it's clear that the provincial government could issue such direction, providing they do so in writing, so that this direction would be publicly visible. If the public felt that this was unreasonable direction, the government would then be accountable for providing that level of detailed instruction to the police. Further, if the head of the OPP, for example, were to feel that those were unreasonable directions on the basis that they could compromise public safety, that commissioner would provide that explanation again in a public fashion so that the logic of where the police were going, either before, if that could compromise the safety of the operation before, that could be explained after, where the police are going and why. What decisions in relation to managing protests should be made by the police alone? At the level of power, nobody should have any say as to how exactly, when, or in what fashion an operation will be executed by the police organization. So while a board may ask, are certain laws going to be enforced, for example, around the transportation of jerry cans of fuel, that board cannot direct that at a specific time of day, you will begin enforcing these laws in any location in Ottawa or elsewhere for that matter. So finally, on that question of policy operations, I would suggest it is a helpful distinction providing you break operations down in terms of plans and powers. Powers are obvious and legally defined. Plans don't need to be legally defined. It's just within that space, there has to be that deliberative process. And if there is confusion, if the agreement as to what constitutes a plan breaks down, we do have mechanisms to take this disagreement to other bodies. So for example, my understanding would be when the new COPS Act for Ontario is proclaimed, the Inspector General would serve this role advising police services boards whether or not they are within their rights to ask for certain information and to enforce compliance on the part of police chiefs if they were withholding information that a board was legitimately entitled to. But hopefully with that sort of hanging over them, they would be able to resolve these things through the deliberative process. I think that the last thing I'll say about that is that it is only Ontario and Manitoba in their Police Services Acts that specify any notion of police operational independence. I think it would be beneficial to remove the word operational entirely from any legal definition of police independence. Simply refer to it as police independence, referring to the exercise of police powers, and to specify that boards and political overseers are entitled to issue this type of direction at the level of policy and plans, providing that they do so in writing. For this reason, the private member's bill at the federal level for the RCMP, C308, does have some improvements, but is probably wrong-headed on its specific mention that nobody shall provide any operational direction to the RCMP on any level, although the rest of the private member's bill does have a lot to recommend it. So I can leave that there.
Perfect. Thank you, Professor Kempa. So Professor Pudister, I know that we've had lots of discussions about the policy operations distinctions, and Professor Kempa is already breaking it down to plans, policies, and power, which I think is an interesting way of looking at it. But would you share your thoughts on some of these questions?
Thanks. Yes. So yeah, I want to focus more on the policy operations part of this questioning that we're going through right now. And I think the distinction that we tend to rely on, policy on one side and operations on the other, is really not useful. And of course, this is not a novel opinion. This has been written time and again in commissions of inquiry, starting, I think, with the MacDonald Commission in 1981, but also more recently in the Missing and Missed report by Justice Epstein in 2021. So this is a conversation we've been having for a long time. The reports make it clear that it's difficult to draw a bright line between policy and operations in every scenario. And I would suggest that's not how things actually operate in practice, that we need to avoid these absolutes. So a few examples that are a little bit different than what we've been talking about so far is, if a government is concerned about the disproportionate use of force against a particular group, can it direct police policy and resources to address this? Or is that a matter of operations? Other examples that complicate this are mandatory charging policies developed by governments in issues of intimate partner violence, policies that have existed for decades. We also see examples where the police must have approval from the Attorney General to lay particular types of charges. So even just saying police operations is something that policymakers like boards and governments and ministers have no space, doesn't reflect how things actually operate in practice. As a political scientist, I'm really interested in those questions of policy, and I think police policy should be open to debate. It should be created and evaluated in a manner that ensures accountability for decision makers and transparency. As a student of public policy, I know that its development is not a straight line. We often speak of the policy cycle, the need for ongoing analysis and review of policies. This is important because we want policies that can be revisited if new circumstances or problems arise, so we can amend and revise those policies. But good policies will reflect as best possible the situation on the ground. Generally, when we're having discussions about police-government relations and the policy operations distinction, references are made to the principle of police independence that Malcolm mentioned earlier. Routinely, we see elected officials comment on the proper role of government as limited in the face of respecting police independence. Statements like, "We can't direct the police," or "We can't tell the police what to do," are not necessarily accurate. Here we see references to the police being answerable only to the law itself. In my view, this is not a helpful understanding for police independence. As was mentioned earlier, the Supreme Court of Canada discussed police independence in the 1999 decision R.V. Campbell and Charose. Here, the court articulates that when an officer is investigating a crime, they are not acting as a government functionary or agent of anyone. The court draws connections between police independence from the executive as fulfilling the constitutional principle of the rule of law. However, I want to emphasize that in this case, the court was only speaking on police powers of investigation, and the decision does not provide guidance for other forms of policing or the other duties of the police. I also urge us to think about the distinction between accountability and answerability versus that of control. My perspective is that there's need for more government responsibility in policing, certainly at the federal level, and not less. Police independence, or some prefer the term operational responsibility, should not be interpreted in a broad manner to cover all things operational, which I think Michael agrees with. Instead, it should be narrowly tailored to respect what are sometimes called the quasi-judicial role of the police: investigation, charging, and prosecution of particular individuals. In other matters, this is where the space for government and policy can come in. Democratic models of police-government relations recognizes that for some decisions of policing, it would be improper for the government to make determinations. Of course, for example, a government cannot say, arrest this specific person. But it is important for the Police Service Board or the relevant minister to be informed of aspects of police operations to ensure accountability and democratic input, and to allow ministerial authority to intervene in policy matters should they arise. Ministers have an obligation to develop policies, review those policies, and explain and defend them in the legislature. When governments do not fulfill their duties to provide direction, we have to rely on after-the-fact accountability mechanisms, like courts and oversight bodies. Based on my research, these are limited mechanisms for accountability. They only come into play after the fact, and they are difficult to ensure outcomes. Courts are highly restrictive, they're expensive, they're hard to access, and I can speak later, if necessary, about the very important challenges faced by police oversight agencies. Importantly, after the fact accountability mechanisms, the harm has already been caused. They have a limited function to act in a preventative manner, whereas policies set by police boards and governments that reflect on-the-ground operations can potentially serve a preventative function. So the final thing I'd like to say before turning it over to one of my colleagues is that I think public order policing can be understood as different from other types of policing and may invite greater government involvement, whether that's from the minister or the Police Services Board. And I'd like to articulate why this is different. Public order policing, we have competing demands and rights between those who are engaging in protest, but also third parties and other communities that can experience significant consequences because of those protests. There can also be concerns regarding access to public and government services, and of course, concerns about foreign relations. There might also be important considerations of protecting vulnerable groups. Here, the line between policy and operations becomes much less clear, and specific processes and procedures for government direction may be warranted. I'll leave it there.
Good, thank you. Mr. Teschner?
Thank you. Judge Morden in his report used a constitutional law analogy and talked about the importance of no longer seeing this idea of policy and operations as watertight compartments. I would certainly agree with that. I would also say that we have to stop seeing it as versus and start seeing it as and. There's a symbiotic relationship between the policies that are set, the priorities and objectives that are set by a police board, or in the case of other police organizations in Canada, by the government, and the way in which the operations are carried out by our law enforcement actors. Judge Morden also provided, I think, some very important thresholds that we should keep in mind. Not every instance of police action will merit the application of a board's governance and oversight function in the circumstance. And Judge Morden coined the term critical points. These were the threshold at which a police board or commission should become engaged because the policing operation that is being contemplated or unfolding, the event, is organizationally significant. It's not focused on one detachment or one division. It brings into play the entire police service and the command of the police service. Judge Epstein, in her report, Missing and Missed, expanded on Judge Morden's critical point definition and said that it should also include major operations that could have an impact on the police service's reputation. Again, classically a role that a board of directors would become engaged in. And also operations that are likely to have an impact on the police service's relationship with marginalized communities. But when I look at Ontario's Police Services Act, which I actually think is a pretty decent structure that requires perhaps some interpretive improvement, I'm less concerned about Section 31(4) that talks about the board's role and the board's limits, And I actually think a lot can be gleaned from section 41(1) sub A, which speaks about the role of chiefs. And it says that it's the duty of a chief of police to administer the police force and oversee its operation in accordance with the objectives, priorities, and policies established by the board. So the board does have a role in providing direction, and governments, where there are no boards, have a role in providing direction. They do set the priorities and objectives. And Judge Morden said, not just in general with respect to an annual business plan for the police service, but in the context of a critical point, when a particular event is being planned or unfolding. It's the board's role to establish, in consultation with the chief, what are the priorities for the policing of this event? What are the objectives that the police service should be seeking to fulfill? And what policy infrastructure is going to be put in place in order to carry out those functions? Once the board defines those priorities, objectives, and policies, the police service does its work. It develops the operational plans required to carry out that mission and achieve the identified objectives. I would argue, though, that the board's role is not over then. The board should stay engaged in the life of the operation. It should review what has been put in place by the chief, not for the technical elements for which it really doesn't have the expertise, but to confirm that the plans are consistent with the priorities, objectives, and policies, and importantly, that the board is satisfied that adequate and effective policing will be delivered in the municipality or jurisdiction for which it is legally, that is, the board is legally responsible. And of course, the board should ask questions about the plan. Was anything else considered? Why are you confident that this plan will work? If plan A doesn't work, what is your plan B? These are all kicking the tires that boards should do. So let's talk about this policy and operations distinction. Judge Morden in his report said that apart from being impossible to apply in its own terms, this statement does not represent what the statute, that is the Ontario Police Services Act, provides. Not only is it not meaningful, in my view, it's the culprit for decades of misunderstanding of the police board role, and in some sense, the reason that the full promise of independent civilian police governance and oversight has not been fully realized. A board can develop policies, priorities, and objectives that affect operations without impermissibly directing the chief of police with respect to core law enforcement functions. And policies and directions that have no impact on a police service's operational activities are meaningless. A board, of course, does have limits, and both Professor Kempa and Professor Pudister have talked about the case in Campbell and some of those limits. I would say that there could be perhaps a gloss put on the Campbell case. Really, where boards should step back and not direct police is with respect to the discretionary law enforcement power that police possess in our system. Whether that's a determination about who to investigate, how to conduct the investigation, who to arrest or not arrest, what search warrant to carry out, or what to do on the ground in the context of public order maintenance in a protest. These are discretionary law enforcement decisions that are within the full view and protected sphere of police independence, if you will. But the infrastructure in which it's carried out, the priorities, the objectives, the policies, that is the role of the board. And so I think in approaching it this way, rather than an either or, we can start to appreciate the symbiotic relationship that should exist between these two functions. Now, Professor Puttister talked about this in the context of policies, and she mentioned one that I just want to illustrate through an example: a disproportionate impact on use of force against particular populations. In Toronto, the Toronto Police Services Board put in place a race-based data collection, analysis, and public reporting policy that is lengthy, is dense, and is detailed. It's not just high level, it talks about what the priorities and objectives are in that particular space. And it compels the chief of police and the service through him to put in place action plans to identify the results of the analysis, the disproportionality where it's found. Many would say, in the past or even today, that's an impermissible intervention in day-to-day operations. You're telling the chief that they have to develop plans to address a specific issue, and you're creating the infrastructure in which that occurs? And the answer is absolutely. That's the role of the board. And the Toronto board has taken this role in the context of artificial intelligence, body-worn cameras, things that traditionally have been seen as the domain, the sole domain of the police service. But that infrastructure in which it's carried out is absolutely the domain of the board, in consultation with the operational leader that has the expertise to express how these things are going to impact the way they do their job in an effort to try and find a place that makes sense.
Thank you, Mr. Teschner. Professor Thorburn?
Yes, thank you. I'm glad to see that there is some convergence on some of these questions among the panelists. The question of what exactly the scope of government input might be into police operations turns on a number of questions. As Professor Kempa already pointed out, there's a big difference between providing specific directions and asking for information, and even making suggestions and calling for a response. In those kinds of questions, I think what we need to do is keep in mind also, as Mr. Teschner pointed out, recognize that it is not a simple model of setting down policy and then leaving it to the chief to create specific day-to-day directions based on that, but rather a relationship of the flow of information in both directions, and a give and take on questioning how those particular implementations are going to be made out. What I want to suggest, though, is that in certain contexts, the foreshortened time window of planning and execution is going to make that dynamic ever denser. That in some contexts, planning and priority setting can take place well in advance. That kind of discussion can take place in a way that is more easily insulated from day-to-day operations because it happens long before those day-to-day operations take place. In circumstances like the ones we saw earlier this year, in Toronto at the time of the G20 and a number of other events, sometimes the flow of information needs to occur much more quickly, and decision-making as well. And so I think the easier distinctions that we're drawing as to whether or not we are making specific directions to day-to-day operations becomes much more difficult to draw. So bringing this conversation back to one of the questions we were first asked to discuss about whether governments should provide directions in establishing priorities for which regions police resources should be deployed in the usual case where timing is such that it is much, where we have time to set out broader policies with broader set of directions, that may not be required. In situations, in some of these critical point situations, the time window is going to be such that the flow of information, the flow of directions will be virtually simultaneous with some of those policy day-to-day decisions. So the kind of input, it would be unrealistic, I think, to say that the kind of input boards might have could be fully insulated from that kind of operationalization. So would it be best to try to insulate oversight boards and particularly ministers, in the case of RCMP and so on, from directing chiefs on those specific matters? Absolutely. That although I would want to emphasize, I think that public order policing is a very significant step away from the specific law enforcement role of police with charging and so on. It is true that nevertheless, we want to make sure that the government of the day is not giving specific directions on those questions. Given that time window, however, I think it's unrealistic to suggest that we can keep them quite so separate.
Okay, thank you. So I knew when I budgeted 20 minutes for operations versus policy, that would be too limited, and we could probably do another hour on that, and we won't, I'm sad to say. But I did want to just make sure, because I haven't been looking closely at our online component, whether Christian or Professor Leprecht wants to make any comment here, or Chief Raymer, because you haven't been in this discussion. So or can we move along to information share? Oh, Christian's got the hand up function. Yes, Professor Leprecht, please speak slowly.
Christian Leprecht au microphone. I'll just keep this brief, but I think we've had this theoretical and legal conversation. Let's take a sociological approach to this and look at the G7, G20 in Toronto. On the Friday afternoon, it got rowdy, and the locals complained, and police took a heavy-handed approach. And we know what the consequences of that were. And so I think that response and the subsequent Morden report and so forth have had a chilling effect on the way we police mass gatherings ever since. And given that the chief in Ottawa at the time was present at the G7, G20, I think this very much would have informed his response. We also need to consider that in Ottawa, under the circumstances, with only the Ottawa Police Service on the ground, had there been, for instance, a more aggressive posture, there's a high risk that the police would have had a rebellion in his own ranks on his hands. And so this is why I think this dialogue and conversation is so important. And I think ultimately these questions of direction need to take into account also particular circumstances and also the size of a police service. And so inherently, the question of direction, I think, looks differently in Toronto in a large service with large capacity than it does, for instance, in Ottawa of a more medium-sized service. And so trying to marry the theoretical and the legal remarks, I think, with the sociological reality and the reality of resources is, I think, important to keep in mind for this conversation.
Thank you. That's very useful. Chief Raymer?
Yes, just one quick comment. What I would say is that police know and have training and expertise to execute law enforcement functions. But what we do is made more legitimate when it has the benefit of independent oversight that's framing what we do. And I think that's the essential ingredient.
Thank you. So now we're going to turn to information sharing between police and government. And some of these discussions, I think, will overlap. But we're going to focus more particularly on the following questions. What information may police boards and governments legitimately request from police? How can requests for information be distinguished from direction? Is there a danger of it being taken as an implicit direction? In what circumstances, if any, may the police decline to provide information as requested by police boards and governments? Is it a problem for departmental officials to speak directly to police below the chief commissioner level to get that information? And what about elected officials doing that, making those kinds of communications? What reports should police routinely provide to public authorities about their plans, activities in relations to protests? So there's a lot there, but Mr. Teschner is going to give us the first attempt at answering those questions.
I'm batting first on this one, I guess. Let me again pay homage to a great mentor of mine and somebody who I think made a significant contribution to this space, and that is Judge John Morden. In his report on the G20, he talked about a consultation protocol that should exist between boards and chiefs of police. And I'll substitute boards for government entities or ministers where there isn't currently, at least, a proper governance board. That information exchange was the first element of Morden's consultation protocol. Without access to all relevant information, the ability to ask specific questions about the operation and the plans, details that are contemplated, ongoing or completed operations, independent police governance bodies cannot fulfill their statutory function. A board can't ask a chief questions or turn its mind to articulating priorities, objectives, or policies about things of which it's unaware. You don't know what you don't know. And so the concern about a board not asking questions out of a misplaced fear that it will be accused of treading on operational matters, this is, I believe, as Professor Kempa put it, a timidity that has become dangerous to a board fulfilling its statutory mandate. It's created escape hatches through which the policymaker, that is the board, and the policy implementer, that is the chief, have each avoided responsibility. And so the burden, in my view, is on the chief to take initiative in ensuring that the board is properly informed about matters, past, present, or future, that fall under the purview of the board's responsibilities. And once he or she does so, that kicks in this consultation protocol, beginning with the information exchange. An information exchange, by the way, that is reciprocal, in that the board should be consulting with the chief on areas that it's considering. Judge Epstein, more recently, doubled down on this information exchange and said that only after a full appreciation of contemplated or completed operations occurs will the board be able to truly deliver on its statutory mandate to ensure adequate and effective policing. The only informational no-go zones, in my view, is information that a police chief is prohibited from providing to a board as a result of a specific statutory prohibition. So an example to that would be information about an ongoing wiretap operation, because that's prohibited under the criminal code, or where otherwise prohibited by common law. So an example there would be informer privilege. Or thirdly, where they're precluded from doing so as a result of a specific court order. Otherwise, and I know some may consider this controversial, boards have and should have full access to all information. And that includes, for example, information about intelligence that a chief of police believes is important in helping define the plans for a specific event. And so, as Judge Epstein said, the answer to a concern about whether giving access to information could be seen as direction is not to foreclose boards from making non-binding recommendations, expressing opinions, or gaining access to that information, but reminding boards that when they're getting this information, they should be anchoring it to their priority, objective setting, and policy-making functions, to their mandate. We also need to remember that board members and chiefs of police are adults. If a chief of police believes that the way in which a board is engaging in a conversation goes too far and gets into the direction of police discretion, they should say so. And there are mechanisms in law and in certain statutes that if saying so isn't enough, that decision can be reviewed. But the board has a role to play. We cannot say that as a matter of law, boards are statutorily responsible and liable for ensuring adequate and effective policing, and on the flip side say that they're not entitled to a whole bunch of information about how policing is going to unfold in the jurisdiction for which they're responsible. Now, in terms of elected officials, my argument here would be that elected officials should not be reaching in to police leaders in order to understand what's unfolding, what the plans are, because it puts both the police leadership and the elected official in a potentially precarious position. A board or commission is the conduit so that we can maintain both a real and perceived independence of that core police discretionary function. And at least where statutory police governance exists, it is the board's role to ensure adequate and effective policing, not elected officials. It's the board's role. And so that's where the elected officials can come. And then it's up to the board to keep those officials up to date on areas of concern, listen to their concerns, and help translate those concerns through their governance function to the chief of police. In terms of what kinds of reports or information police should routinely provide to public authorities about their plans and activities relating to protests, I would say that the model that we adopted in Toronto for the Freedom Convoy is a good one. This was clearly a critical point, to use Judge Morden's term. And the chief came to the board and said, we have something unfolding, and I want to make sure that you're fully briefed. And the board's institutional report at page 13 outlines the various types of information that the chief and his team provided in that briefing. The key context for the major event in operation, including known intelligence that's animating the operational planning, suggested priorities and objectives for the board to consider, the command and control approach that was going to be taken, especially if other police services from outside the jurisdiction were going to be involved, a lesson learned from the G20. Confirmation that the board's existing policies and legal authorities in place provided an adequate framework for the policing of the Freedom Convoy. A discussion about whether the service required any specific board approval associated with its planned operations. A discussion about the adequacy of the service's resources for handling both the major event and whether there was a need for other services to participate and lend support, and what the legal infrastructure was going to look like for that. Of course, also the adequacy of general policing services, so that while that event was happening, the board's statutory role to ensure adequate and effective policing generally in the city can't be forgotten. And so business continuity was discussed. And then importantly, public and stakeholder communications before, during, and after the operation. All of these areas of information were put on the table by the chief and his team, were discussed by the board, gave them an opportunity to ask questions, and ultimately to determine whether they were satisfied that the plan that was in place would ensure adequate and effective policing in Toronto.
Thank you. I'm going to let Professor Thornburn in a second, but I just wanted to allow Chief Raymer if you wanted to have any comments about the Toronto information sharing.
What I would say to you is that when I was appointed chief in August of 2020, one of the things I instituted was a morning brief to the executive director and the chair of the board to give them an idea of what was happening overnight and what we as the police organization and the city were being confronted with. And then, of course, when you had a priority incident occurring during the city, I would give them an immediate briefing as to what was transpiring on the ground and what we were doing about it, and keep them apprised just so that they were aware of what's going on. I found that it was an essential part of that information sharing, so that the board had an appreciation of what we were doing, what our capacity was, what our weaknesses were, what our resource issues were. These were all important things for the board to understand. Because it was important in terms of they oversaw budget recommendations, guidance, policy, and direction, and they had to be involved so that anything that they decided to implement what was going to be the operational effect of those decisions. So they had to be done in collaboration, and they had to be done with knowledge and of actually what we were being faced with as an organization. So I just wanted to add that point in and to the importance of it. And with respect to, how can requests for information be distinguished from direction? And I think there's always an opportunity where the lines are going to be blurred there. When you look at the danger of actual or perceived direction from government to the police. But that's the origin of commissions and police boards, and that's why we need them.
Do you have any comment on the question about whether police chief may decline to provide information? Mr. Teschner gave us some examples of where it's statutorily barred, but do you have any reservations about other types of information?
Yeah, no, quite frankly, no. I mean, there's things like informant privilege that we do, any type of, secret operations that we'll have going on, we don't discuss. We might discuss them after they're done and talk about some success, but not while they're undergoing, not while they're occurring. But other than that, as far as I'm concerned, there's an oath of secrecy, and the board cannot perform an effective oversight function if they don't understand what we're doing. Many of them, was mentioned earlier by the professor, are not police professionals. In some cases, we have lawyers, and then you'll have city councilors and people selected, like social workers selected by government to be on the board. But we have to inform them so they have an understanding. And without that information coming into them, it makes it very, very difficult for them to do their job. And then conversely, as to, I think one of my colleagues mentioned earlier, one of the benefits is that when we're having these discussions, and my team is letting them know what we're going to do. And by the way, we're letting them know that this is going to cost several millions of dollars, so you need to be aware of this. They're also making sometimes suggestions. How about, are you communicating with city councilors so they got an understanding of what's going on? They could become helpful to this discussion with the city. That's a good idea. And so we then got on and we made sure that we communicated with every city councilor and gave them a little bit of briefing on what was going to happen over the next couple of days. So that collaboration has benefits that makes us much more successful in what we do.
Thank you, Chief. Professor Thorburn, thank you for being patient.
Thank you very much. Yes, I just want to say a couple of things. I think what we saw in the operation in Toronto on the Freedom Convoy was a convergence of greater democratic accountability and a successful operation. And so the extent to which information was shared and this not only provided greater input and democratic accountability, but also greater operational success, I think you can show that there's kind of synergies that are at work there. What I want to emphasize, though, is that there are plenty of places where that has not happened. And in the existing framework, other police services have felt still constrained, even 10 years after the Morden report, constrained in the kind of information they're sharing, not ensuring the kind of free back and forth of advice that Chief Rayner was just describing that you were able to benefit from in the operation with the Freedom Convoy there. And so what I want to emphasize here is a little bit, is quite similar to what I want to emphasize on that first question, which is that it's one thing to say, here's how we ought to operate, and there's another to provide clear guidance to police forces across the country and to police boards across the country as to exactly how to make sure that they live up to that. And this is where clear statutory language is helpful, and sometimes clear regulations. But on the level of the kind of successful integration of information and democratic input, I think that's a good model.
Professor Kempa, briefly, please.
I wanted to emphasize Ryan Teschner's point that the first point of entry for political influence is a board, rather than direct political engagement by an elected representative in police matters, for the reason that political engagement is rendered publicly visible through the board structure. So there's not a person in Ottawa, for example, who's not aware of the Police Services Board in Ottawa at this point. However, that's not the case for other police organizations. So OPP, the precise board structure is a bit of a mystery to most people in the province of Ontario. Most Canadians would not even be aware that there is an advisory board for the RCMP. At this time, through the RCMP's difficulties, there have been very few public statements of that body. So that is something that has been unresolved more at the provincial and federal level than at the independent municipal level of policing. That the primary port of call for political influence at the municipal level is a board. It's fuzzier at the provincial and federal level.
Thank you. Professor Lebrecht, very quickly.
Well, I'd say one litmus test is that we have a long way to go on this. If you look at police budgets, for instance, it can be exceedingly difficult, even for boards, let alone the public, to understand where exactly the money is going and where exactly people are being deployed. So that, I think, is an interesting exercise. The issues that were mentioned here, ultimately, this comes down to policy, right? So do we have and in Ottawa, an outdated major events policy? We need to establish these beforehand. So boards need to establish a policing designated major events policy. They need to establish a policy with regards to chief to board communications. They need to establish a policy on information sharing, sharing protocol during emergencies. And that ultimately looks different for different police services and different boards. But I think we've heard that Toronto here is leading by example, and there's a lot to be learned.
Thank you. And actually, that's a good segue to our next set of questions, Professor Lebrecht, where we're going to talk about different police services and different relationships. Because right now we've been talking about kind of the police and the government, right? But we actually know it's much more complicated. Some of the issues arising in this commission are much more complicated because we have the RCMP, the OPP, Municipal Police Force, the Ottawa Police, the Parliamentary Protectory Service. So we've got all these relationships going on. So we want to probe that a bit. Does the RCMP's relationship with the government and the minister change when it's in a contracting role, as it might be in other provinces other than Ontario? Where we have the OPP, and we don't contract with the RCMP. What role does the provincial government play in those situations? And thinking more about police services boards, particularly when we have one force, the RCMP, that doesn't have a police services board, right? So we don't have that model. So we've got all these different forces with different institutional arrangements. How does that complicate everything we've been discussing? Professor Lebrecht.
So there's 4 police services in this country that I'm aware of that do not have the board structure that we are talking about. The RCMP, the OPP, the Sûreté du Québec, and the Royal Newfoundland Constabulary. And we see the challenges that raises, for instance, for the RCMP when we look at the Mass Casualty Commission in Nova Scotia. So that's, I guess, the first observation. The second is that boards can find themselves challenged. Most appointees to boards don't necessarily have the expertise, have the experience, and have the time that they need, because in most cases they're volunteers and they don't necessarily come from any sort of public safety background. And so I think there's a considerable gap, and that asymmetry often works for chiefs, in the sense that chiefs can sometimes rule with an iron fist, especially when they face boards that don't quite understand their particular remit. The third is that it is the benefit of boards is that you have, as Mr. Teschner outlined, the ability to develop a strategic plan that sets outcomes, which we refer to as priorities, but that also defines outputs that are measurable. Those are what is known as objectives, and the way we translate those outputs is then through policies. And while that happens at the strategic level, it also needs to happen with regards to certain elements of operational elements as defined sort of by policy, as we had sort of in the previous conversation. Ultimately, information sharing on a high level is also always about trust. And I think we have serious challenges when it comes to trust within police services, between the chief and often associations, not to speak of any particular service here, but people will be familiar with forces in this country where this has come to the fore. So it's difficult, I think, for a force to be effective. And so boards ultimately need to make sure that those relations are working well. If you have a police service without a board, it is going to be, I think, more difficult to have insights in that regard. And you also ultimately need to have trust with other stakeholders and agencies. We'll get back to that in a couple of questions. I would like to close when we're talking about the relationships among different police services, that this ultimately are fundamental questions about police governance. And I would say that if you look at the recent webinar on police governance held by the Canadian Association of Police Governance, with some terrific interventions, I would say that police governance in this country is extremely challenged, and that one of the opportunities for the Commission here is to provide a way forward on police governance more broadly, because if we can remedy the shortcomings on police governance that were on full display during the Ottawa convoy and the meltdown of the board during a local and arguably national crisis, then that means we wouldn't need to invoke emergency measures to try to remedy this, because ultimately we need robust governance mechanisms.
Anyone else want to comment on that set of questions? Oh, Malcolm.
Just a quick intervention. Just want to emphasize that it's all the more important, first of all, that we look at board composition, not only in their representativeness, but also in their ability to provide useful interventions and to know what questions to ask when serving on the board, to be able to provide useful insight. The model that several of us have been discussing this morning of flow of information, question and answer between board and the chief requires that the board members have a certain level of ability and knowledge of some of those areas in order to engage in that kind of conversation. I just want to emphasize also something that I think goes without needing too much emphasis, but the centrality of some kind of intermediary between elected government officials and police chiefs, that organizations like RCMP and so on, where we lack that board structure, there is a real concern about sliding from democratic accountability to too much a too close relationship with the government of the day.
Thank you. Oh, Mr. Tester, sorry.
Just very quickly, I do think that this is a circumstance in which, even though they don't have constitutional status, municipalities can teach the rest of the country perhaps a lesson. Where there are governance gaps when it comes to independent civilian governance, they should be filled. The management the management advisory board for the RCMP was mentioned today, and while I think that's an important step along a transition, and I know that the more recent mandate letter to the Minister of Public Safety asks for enhancements in this area, I don't see any real barrier, statutory, legislatively, legally, or otherwise, as to why the RCMP cannot one day have a truly independent civilian governance and oversight body. And I would say the same for the others that Christian mentioned here. The reality is that those boards are the intermediary if they do their job effectively. And it gives real definition to some of the principles that we've been talking about today. And so I would just urge the decision makers, and perhaps you, Mr. Commissioner, to give some consideration to that.
In the interest of time, I'm going to collapse some of our questions, and I'm going to turn now to a related issue with respect to all the varieties of different police forces, and that's about collaboration. So, Chief Raymer, I'm wondering if you could give us some insights about how collaborations between police organizations should be managed. Particularly, I know this commission is interested in the deployment of multiple police agencies' resources, how they can be coordinated during a major event, especially one that affects multiple locations through the province.
I think when it comes to collaboration, there should be informal, as well as formal avenues to secure collaboration. The formal ones should be available when the informal ones, frankly, are not working. I find that we work very effectively in collaboration with our other police services. When, if you look at the Freedom Convoy in Toronto, During the course of that entire event, we had created public order hubs throughout the province because we knew, the participants had information and they were being very strategic in how they deploy. So they were in Ottawa, they were in Windsor, they were in Toronto. There's a reason for that. And the reason for that is because there's only limited POU assets in the province and they want to spread them around. That was very strategic on their part. So we create these hubs to sort of manage that, and we designate people to oversee those hubs, and quite frankly, they work very effectively. When we were looking at resources in Toronto, the OPP provided resources, Waterloo provided some POU assets for us, and then Peel, York, and Durham were also communicated with, and they were going to help with business continuity if we were finding ourselves stretched and unable to meet our business continuity demands. Those were all just informal communications, easily set up, easily maintained, and they were reciprocal if all of a sudden an event ended up, say, being staged in Peel region. And so Nishta Riapa and Jim McSween in York, we're all having those conversations, very easy to move those assets around and work collaboratively together. And I have to tell you, it works very, very effectively. Now, when you have, and even despite what was going on at the time here in Ontario, and we had, you had what was happening in Windsor, you had Toronto, there was up London Way as well, we had events as well as in Ottawa. We were managing those assets. When you look at what happened in Windsor, quite frankly, in my view, was textbook, and how that was addressed. And when you think of the lack of injury, people being, wrestling around and rolling around on the street and people in handcuffs, none of that happened. It was done very, very effectively. It was communicated what was going to be done, and then you made sure you had the resources in place to conduct it. And so that was all done with that kind of collaboration. I think sometimes when I talk about the formal processes is, within the Police Services Act, it's almost like an all or nothing thing. So in other words, if someone's not managing, then maybe the OPP are coming in. Well, I'm not sure that's the answer as well. If you look, I think I refer to Windsor again. If you look what was happening there, the OPP were brought in with assets to conduct that public order because they had the expertise in that area of the province to actually exercise that. And they did that in conjunction with the acting chief at the time. They sort of looked after, Windsor was looking after business continuity. The OPP came into the POU. They worked collaboratively together. It was very, very effective. So I don't think it has to be an all or nothing thing. I think if we were to hypothetically look at potentially being something so overwhelming and bad, if we are going to have the application of something more formal, it needs to be more easily done, and there needs to be a formal path to do that much easier, in my view.
Thank you. Mr. Teschner, briefly, please.
Yeah, just a brief point. I do think that the police service and police board sector would benefit from a little bit more rigidity in terms of the structure. Flexible, but structured. And so I'm aware, for example, that the Ontario Association of Chiefs of Police is working on template MOU or agreements so that where boards need to seek assistance from other boards for a particular operation on the basis of a chief's recommendation, there's already a framework agreement that's in place that boards and police services would be aware of. It would address things like cost sharing, training if there are any issues, command and control considerations, so those things are clarified, insurance matters if those things come up. And so having some of this on the ready that everybody is familiar with and understands means that the toing and froing that can sometimes happen during the life of an event is already been resolved. And so I think that there's an opportunity there, perhaps even to take that around the country.
If I could just, that's actually a good point, because I think when it comes to MOUs, quite often we're only looking at MOUs if there's going to be a financial cost. So in other words, if a region says, no, we'll send you the POU and don't worry about overtime or salary dollars, we don't bother with an MOU. But we do already, training is all done together amongst all those public order units. So they already train well together and they know what each other are doing. But the point of the MOU is it's usually a financial component that initiates that MOU discussion.
Chief Raymer, I wonder if we could, we talked a lot about police independence pretty vaguely and generally, basically the police as a whole independent from government. Could you comment on police independence within the force? So incident commanders might have some independence, right down to the line officer. Every police officer has a scope of independence. I wonder if you could tell us more about that.
Well, I mean, all police officers are independent agents of the Crown, but when you have an operation and you designate an incident commander, the incident commander is in charge, not the chief. The incident commander is in charge, and he will direct all operations. Really, at the role of the chief, my only role is to oversee, ask questions if I have any concerns, and if I'm unsatisfied with the performance of the incident commander, to replace them. But my role is not to direct operations. If the chiefs were constantly directing operations across, you'd see us in court every day. And that doesn't happen for a reason. It's not our role in managing an event. You have trained experts, and those are the ones that you allow to carry out the event. We have expert planners. The operational plan is approved. It's not approved by me. I'm briefed on the operational plan after it's approved, but it's briefed at a senior command level, but not by me. And then it's operationalized. And then that incident commander there's a review team of chief superintendents that will sit and be an advice to that individual, to help guide them, provide some instructions, just as a secondary thing to help that incident commander fulfill the role, particularly in a very high-profile event. And that's something we found was missing in the G20, and it was something we implemented afterwards. But you have to allow the people that are designated in their role to actually carry out the operation. And then because when you designate who's clearly in charge, everybody else now knows who's making the decisions and what that chain of command is. And to me, that's what leads to a successful operation. When that G20 was going on, I was sitting in my command boardroom and I was watching what was happening on TV with with the fire chief, my deputy. We would brief our executive city managers every couple of hours just to let them know what was going on, because there were so many different assets that we were using throughout the city. But that was our role. And I might have a question or something, but that's it. The incident commander was in charge.
Thank you. Do any of the academics want to probe that a bit? But we've talked a bit about police independence. Does that complicate any views on that? No. Okay. Everybody's happy. So we're nearing the end of our time. We've got about 15 minutes left, and we've got a big section of questions next. I'm going to call a little bit of an audible here and restrict us just to the first two questions on the list, which are what changes to legislation might be appropriate, and what laws, regulations, policies, or norms governing the powers and responsibilities of police in relation to the public processes and their relations to public authorities, well, this is a long-winded question, should be revisited. So this is really the question, to think about the rules we have in place, the legislation. What would your prescriptions be if a commissioner was to make such recommendations? Professor Prattister.
Thank you. Yes, so I'm going to suggest two. The first is not novel or new and has actually already been mentioned already. But I think one of the biggest challenge for police-government relations in Canada is thinking about the RCMP Act. So we've had a lot of really great conversation about what Toronto has done, and I think that's a really great model. And I think things are working well there. The Ontario Police Services legislation has some more defined roles about police-government relations and police independence. But when we look to the RCMP Act in Section 5 in particular, we find none of this sort of guidance. So the current situation federally with the RCMP really lacks a statutory framework and articulation of police independence. It's unclear who can intervene and when, the nature and scope of that intervention. There's no clear guidance on what process should happen if there's a disagreement between the minister, so the Minister of Public Safety, and the commissioner. This, of course, results in a lack of transparency and accountability for those who are involved. Because of this, with the RCMP, our situation relies heavily on leadership and decisions of key actors, and that they will act in good faith. Here, I'm going to put the suggestion on the table that policy has an important place here to set a framework to deal with these situations in the future. Having defined, codified definitions of police independence can help address these issues and make it less likely that political or partisan interests on behalf of the government will come into play. So here I'm thinking we can look certainly to the legislation in Ontario as a good starting point. We also want to be reminded of the Supreme Court's decision in R.V. Campbell as a definition for that core function of the police. So here legislation could specify that independence applies to specific operations, such as specific arrests, investigations, and charging. I urge any recommendations to avoid just operations. I think we've spent a lot of time discussing why that's not a useful demarcation point. Thinking through this, it might be legitimate for governments to provide direction to policy as it relates to crime prevention, maintenance of public safety, delivery of services, general law enforcement, while other areas might be less legitimate, like enforcement of law in a particular case, decisions regarding individuals, including individual police officers, and issues regarding individual members of the police service. Of course, reasonable, informed people may disagree where this direction from the government is proper and where it is not. But these are important conversations that can only be had once we take a step towards articulating these matters in legislation. And that legislation can be amended when it's clear that there are errors or gaps. This ensures that we don't have to start from scratch each time. I also agree with the proposal that's been put forward by Kent Roach in a variety of publications that this legislation could require directions be made in writing and be made public between the Minister of Public Safety to the Commissioner, and that these written directions are provided within a set period of time, unless, of course, it would compromise an ongoing police operation or investigation. But of course, that would be the limited exception. The second suggestion I want to put before the Commission and has come up on the side of some of the conversations we've had already is the consideration of a role of a truly civilian police oversight board for the RCMP. The RCMP roots are paramilitary in nature, and the force has evolved in a manner that is distinct from other police forces in Canada that have taken a more civilian approach to policing, like the situation in Toronto. Civilian oversight for the RCMP, in my opinion, is lacking and is out of step with other police services in Canada. The agencies tasked with providing oversight for the RCMP in matters criminal and conduct leave much to be desired. Creating a version of a police service board for the RCMP would help to increase democratic accountability and create opportunities for increasing diversity of those who are involved in governance and moving away from that troubling line, direct line from the minister to the commissioner that was mentioned earlier. A board can ensure that ministerial direction is appropriate and given when necessary. This can be helpful to transition the RCMP away from being a paramilitary organization, which was a recommendation from the recent House of Commons Standing Committee that examined systemic racism in policing. Membership of this board, like boards in Ontario, could have a combination of elected and appointed members, but appointed members could provide an important opportunity to ensure diversity of representation, especially of groups that have a history of distrust of the police and have experienced over-policing from the RCMP in particular. It could also include members that have particular expertise or lived experience that would be helpful in police governance. Like other police boards, the majority of these meetings could be held in public, receive submissions from the public. Similar boards could be considered for provincial jurisdictions in which the RCMP provides policing on a contract basis. I want to end with just one criticism that's going to be obvious. An important criticism would be that a police board would serve to diffuse responsibility. But given the framework that I've suggested and the public nature of these proceedings, the decision of the board and policies enacted would create more potential for accountability and lay true any overt attempts to diffuse responsibility. Of course, the minister would have to chair the board and answer to Parliament to maintain ministerial responsibility, but I'll leave it there.
Thank you, Professor Pedister. Professor Kempa?
Just to say that I agree with everything that Kate Pedister just said, except I would add one precision, or maybe a slight difference, which also follows Roach, and I think can be inferred from other sections of Campbell, that when defining police independence, you simply jettison the term operations altogether and define police independence in itself in terms of the exercise of their powers of investigation, arrest, and the laying of charges. Of course, they do that in consultation with the judiciary and the Crown, but that is the area, and that also follows, as I say, Kent Roach. To echo Kate as well, the importance of the minister being on any board for the RCMP is, I feel, replicated at the municipal level. Mayors should be on their police services boards, for two reasons. Number one, to align policing direction with broader city municipal planning, such as in areas of community safety and well-being, but also just to ensure that there is no perception or reality that there could be any political meddling in policing from any other mechanism or behind the curtains or whatever, other than through that board, if for no other reason to eliminate that public perception.
Thank you. Professor Thorburn?
Very briefly, I think Professor Pedister put it very well, and I, like Professor Kemp, I would say I endorse all of the recommendations that she made. And I just want to summarize some of this by saying that clarity and direction is needed, that there are practices that have been enormously successful, as we saw in Toronto Police Service's handling of the Freedom Convoy, but what we need is guidance to police services across the country to make sure that information sharing, these kinds of decision-making processes are widespread. The same thing is true of clarity, a board structure, and that there should be a board structure for those without one, such as the four organizations that Professor Leubrecht identified. And on the last thing on board structure, I think we can't underestimate the importance of representativeness, both the matter of the mayor representing the city's interests as a whole, but also of underrepresented groups who have a very important role in providing insight to police services.
Thank you, Professor Thorburn. Professor Leubrecht, did you?
So as I documented in my book, Public Security and Federal Polities, there is no other democratic federation in the world that either structures their police services the way Canada has, or that funds their police services that Canada has. And so inherently, there's only so much we're going to be able to do if we try to adjust governance mechanisms, as long as we have a model that seems rather peculiarly unique. And so I think those are questions we need to ask. We also have a federal and national police force where the commissioner has a span of control that is unlike that of any other national or federal police force in a democratic country across the world. I mentioned this in the context of the current review of federal policing by the National Security Intelligence Committee of Parliamentarians that was announced in February. And so I do think that the Commission may perhaps want to take the RCMP's and the Commissioner's span of control into consideration, because I am not sure that this is a model that serves the public interest particularly well, in part because the RCMP is torn in too many directions. And when called upon, when a situation such as in Ottawa transitions from public safety to national security, and you need federal involvement on the national security side, we had a considerable, I think, breakdown in both resources and interagency collaboration. I also believe that there need to be clear qualifications and certification laid out for members of police services boards, because that's essential to them performing their function. And so simply getting an appointment, I think, is not enough. We need to have, Canada is also a bit of an outlier in the way we generate police managers and police leaders. Many of the functions that in other democracies are managed by civilians in Canada are managed by folks in uniform. I'm not sure that necessarily serves the best interest. Similarly, on the leadership side, there's not a country, a federal country that I'm aware of, that requires less in terms of education of senior police leaders that Canada does. And so we have this assumption that somehow people will acquire the skill sets for this extremely complex task. And the fact that only a couple of months ago, I believe 13 forces in Ontario had been looking for a chief of police suggests that we're perhaps not quite generating the leaders that the country needs under these particular circumstances. And I'll close on saying that effective policing, adequate and effective policing is essential for democratic legitimacy. And I think what happened in Ottawa severely undermined the legitimacy of our democratic institutions. And so it is inherently essential for the health of our democracy that the Commission find ways to ensure that we not witness these types of breakdowns again, not just for operational and tactical reasons, but for the broader reasons of safeguarding our democracy and our democratic institutions and our public's faith in them.
Thank you. We only have 2 minutes left, and the Toronto model has received so much praise today. But if you want to capstone it off by some comments, would be...
Actually, if I could go first, I'll just be very, very quick. In terms of potential legislation, I think two things. There should be a board or commission for all police services that currently do not have one. I think that's essential. Secondly, sufficient protection for board appointees to do their jobs, to be free of political influence or the appearance of. So they just can't be all of a sudden removed from by a council motion. And I think, and more importantly, too, boards need the funding. They need the funding to have the people in place, some of the excellent people that we have in Toronto that really enables us to actually ultimately perform a better function. And then the Professor Lupert comment, something I've been advocating for now with the Ontario Association of Chiefs of Police, and that's really standard senior command training. It's something that I've met with the UK on, and they're going to do, I'm bringing some of their trainers here to Toronto in the spring to conduct some of that. And I'm just trying to sort of speed up the process and invite other organizations in. I think it's very much needed so that anybody who wants to be a chief superintendent, a deputy chief or chief has to have undergone this training. Right now our training is piecemeal. Some members are getting it, some members don't get it. It largely depends on municipal funding, and perhaps if you're federally or provincially funded, you're getting more access to training. If you're municipally funded, you're getting less access to training. That shouldn't be the case. It should be something where the province or federally, it's a standard either across the country or certainly at least in our province of Ontario, where we have that kind of standardized training. I think it would be very, very effective. And a final comment I make is we currently have 2 deputy chiefs in Toronto that are civilians. Our innovative and technology deputy chief, Colin Stairs, and our CAO, interim CAO, Savina Dhaliwal. And they are an excellent addition to the team, and they bring an expertise and an outside thinking that we have not, we generally in policing, you don't experience. And in fact, I will tell you that Colin Stairs, our IT specialist, leads our race-based data discussion and is doing an incredible job with it. He's not a police officer. So there's great value in that as well. So I just wanted to echo the professor's comments.
Thank you, Chief. Mr. Tester?
Thank you. I'll just amplify some of the recommendations. First, Commissioner, I would say that harmonizing the approach to police governance through legislation and otherwise does not necessarily need to upset the constitutional order. And so there's an ability to make recommendations to bring to bear some of what was discussed today in terms of best practice. For example, the statutory roles and functions of police boards and commissions being made more clear. The definition of police independence that piggybacks off what happened in the case of Campbell, and I would suggest with my suggested modification, narrowing it more to the exercise of police discretion in the law enforcement function. A legislative definition of critical point with the attendant information exchange obligations. Mandatory training requirements for exercising the governance function, and for chiefs and command officers to receive mandatory training on engaging with their governance bodies. And then the chief mentioned mechanisms to protect, from a security of tenure perspective, if you will, board members in certain circumstances. Secondly, I would just say again, ensuring through legislation and other tools the ability of local police boards and services to seek assistance nimbly and in real time without compromising their ability to remain the police service of jurisdiction. Template agreements, MOUs, and the like established in advance so that some of the legal issues can be thoughtfully worked through and not necessarily dealt with on the spur of the moment. I've talked about, as many have, a fully independent civilian governance and oversight body for the RCMP, so I won't repeat that. And then I would say two things from my front row seat living within the world of police governance every day. All of these recommendations are great in theory, but you have to set boards and commissions up for success. And I would say there are two ways that you could potentially do that. One is, I am not aware of another government function where the tall order that boards and commissions need to fulfill are not fundamentally and adequately supported by professional civil staff that supports those boards and commissions. And I think resources and a consistency of approach needs to be brought to bear to ensure that part-time board members who are doing other things and may not necessarily have the expertise within the public service or otherwise are supported by independent civil servants. And the second would be to establish tripartite partnerships, municipal, provincial, federal, with a mandate to establish regional centers of excellence for police governance across Canada that can, again, bring some consistency to the approach that boards and commissions take, allowing them to still manage local issues, but on things like critical points, information sharing, consultation protocols with chief, approaches to certain policies. So there's a consistency of best practice approach. Those would be my recommendations.
Thank you, and thank you everybody for a very enlightening discussion. And I said at the beginning, there were no easy answers, but there was lots of consensus, and I think lots of things that the commissioner can use and draw upon.
Okay, so I think we now take a break, and we'll see whether we got some questions, and we'll come back with those questions and maybe some others, and have a half hour of discussion starting at noon.
The commission is adjourned for 30 minutes. La commission est levée pour 30 minutes. The commission is reconvened. La commission reprend.
Okay, so we're back, and as I understand, we have a few questions. So I turn it over to our moderator.
Thank you, Commissioner. You'll be all pleased to know that your comments generated lots of questions, and I've got a whole list of things that we probably won't be able to get through in a half an hour. But let's try and move through them as quickly as we can. We talked a lot about prohibited direction. So when we talked about police independence, we said you can't interfere with investigations. Everyone basically has that kind of understanding. But how does that apply in the public order policing context? So what would constitute a prohibited direction in specifically that context? So not in investigations, but in public order. So the commission would, the parties would like to know about a sharper definition of that. So some examples that were proposed were whether should you negotiate with the protesters or act? Should you enforce provisions or not? What if the priority is established as Ottawa first, Windsor second? When does timing become an operational concern? So what are the types of prohibited directions you would see in the public order context? Professor Kempa.
Sure. So I would just say the moment it has to do with the actual carrying out or execution of the operation, that's the moment where the board cannot direct. So the board may have a policy that PLT or negotiation is an important part of mass protest management, but exactly when that negotiation would be carried out would be a police leadership decision, because they would be weighing in the safety of their officers, whether they had identified groups to negotiate with. But then the board would be properly asking questions if they felt that they didn't see, for example, PLT starting. They could ask why and demand a response. And if they were given an adequate reason along those lines, that's basically the end of the matter. And if they weren't given an adequate, they could say, well, when will it be starting? But fundamentally, they could not force the chief to begin on a particular moment.
Okay. Any other comments on that? Yeah.
I would just come back, Mr. Commissioner, to my suggestion that you add on to the Campbell definition or clarify it in terms of the exercise of law enforcement discretion. And so what happens on the ground during a protest in a variety of ways, whether it's what tactics to use, when to mobilize your POU, when to negotiate, when to cease negotiations, whether the circumstances don't, in the view of the person on the ground, allow for negotiations, even though that may be the policy because of safety risks or otherwise. These are all exercises of law enforcement discretion that should be protected once the operation is being carried out. And to use an administrative law analogy, the board should not fetter that discretion. They can, again, set the stage for it, set the context for it, identify the priorities and objectives, put in place policies, kick the tires of the plan, ask that certain things be reconsidered. But when the operation is underway, as Professor Kempa said, who's investigated, who's to be arrested or charged, whether someone should be arrested or charged, the number of officers to be deployed for specific tasks on the ground, the time frame for those actions. That is all the exercise of that law enforcement discretion.
So can I just follow up, and Professor Leprecht, I'll get with you to you in a second. Would we say it is a policy matter or an operational or planning matter to say you have to enforce, we want you to start enforcing the law, right? Instead of, I accept, Mr. Teschner, that you don't want to say you have to charge person X. Like that would be clearly an operational or a prohibitive kind of direction. But what about saying we want you to enforce the law? Like you're not taking as proactive an approach. Would that be prohibited?
I would argue that would be an odd direction from the board. Police officers have that independent authority and are required by law to enforce the law based on the exercise of their discretion. They are the experts in knowing what tools to use and when. And so a general direction to enforce the law I think is, as Judge Morden put it, one of those policies that actually are meaningless. That should be the starting point in any event. But when to enforce it, how to enforce it, what tools in the law enforcement toolbox to use, that is the discretion that we need to ensure police officers can exercise. Again, based on a plan with priorities, objectives, and policies staked out in advance.
Thank you. Professor Leprecht?
Yeah, I think this sounds good in theory, but in practice, look, I mean, when you have multiple police forces that are under different sort of jurisdiction, and each of them has sort of either been given some different directions or has sort of been given different priorities, I think the integrated command structure here is critical. And how do you generate appropriate oversight and governance of an integrated command structure, especially when you have some forces that have boards and some forces that don't? The other issue that I would raise is that the question here is a function also of, do you have sort of just straightforward criminality, or are you facing a political protest? And police are the first to know that there is no law enforcement solution to a political protest. You will not arrest your way out of a political protest. And officers know that. And I think there would have been a rebellion of, initially at least, when there weren't enough resources, of officers in Ottawa, had they just been told, you go and just arrest people. And so I think there needs to be, police will look for top cover in terms of what approach do you want us to take? Because if they take an aggressive approach, they know that there's going to be repercussions. So when in doubt, I think police will err on, we're here to keep to maintain public safety. So that's what we're going to do. And we're going to find a gradual strategy out of the situation that we find our ways in. If the political authority is unhappy with that approach, then it needs to set a clear signal that federally, provincially, and municipally, they will have the back of the police forces that are in place. And the governance asymmetries that we have make that difficult in Canada, and especially in Ottawa.
If I could just jump in.
Thank you. Yeah, Chief Raymer.
You know, when you're having these events, I just want to say first off, the police position is always to do this safely and peacefully. No one wants to be rolling around on the sidewalk because everybody's getting hurt. And it's not just the public, it's the police officers as well. And so that's always the goal. And when we look on the events in Toronto on the one day, I believe the 5th of February, we had a number of very large trucks come down Avenue Road and try to breach at Bloor Street, and they were unable to get through. But they ended up staying there during the course of the day. And as we briefed our executive body, which is the different city leaders, the mayor and the executive director, to keep the board informed, they were asking questions, well, what are you going to do? And we just said, well, the vehicles have stopped and people are demonstrating, and we're going to facilitate peaceful demonstration. But consistent with our mission of all day, no vehicles were staying overnight. And so we discussed with the leaders, and by the end of the night, most of them moved on. There was a couple of people and large vehicles didn't want to move, so we brought the heavy tows into place, and then they went home. And so, because they saw that we meant business. And so that was the plan, but the whole goal was to do it peacefully. The board asked questions, and we told, no, we're just going to allow them to demonstrate peacefully. They're not hurting anything. We're there for the day, but we'll encourage them by the end of the night. We will help them move off. And that's exactly the way it did. But my point was that the board had questions, maybe coming from politicians as well to the board about what's going on. Community members are calling in and complaining about the noise in the trucks. We said, this is the way we're going to do it. This is a safe way to do it. They were satisfied, and that's the way it happened that day.
Thank you. Professor Thorburn.
Just a quick intervention. It's just important, I think, that we distinguish areas where the reason why we want to leave police independence is because of their kind of quasi-judicial function in making arrests and so on, from this area where mostly what we're talking about is expertise. And so in that area, we may want to insist we should defer to those who have expertise on the ground making these decisions. But the kind of dialogue that Chief Rayner was just describing, asking hard questions, saying, why aren't you doing thus and so, is entirely appropriate in a way that it would not be when we're talking about specific investigations.
Sorry, just wanted to off something that Christian said about integrated command structure, and I know Commission Council have asked questions about the deployment of resources to different areas depending on what might be emerging. I think it's important to be mindful of the governance structure that exists. In law, the Police Services Board of, in this case, Toronto, is legally responsible for the adequate and effective policing in Toronto. If assistance needs to come from other police services, it is vital, as Judge Morden laid out in the G20 report, for the board to understand what the command structure is. So that, yes, you can have an integrated command structure, but who ultimately has command and control of that event? And so through the MOU process that I suggested happen, these kinds of things should be worked out and should be clear. So there's never any doubt operationally and never any doubt from a governance perspective as to who has command and control, even though you might have multiple units involved at the same time.
There were some questions actually related to the request for other forces to assist and Section 9 of the Police Services Act being invoked. And there seemed to be some perhaps reluctance to do so in certain cases. And this got back to a comment you made, Chief Raymer, about all or nothing, right? The Police Services Act sometimes interpreted as all or nothing. Is Section 9 a kind of all or nothing? And this is for the panel as well, an all or nothing request. So once you invoke Section 9, suddenly the OPP is in charge of the operation and there's a kind of takeover of the operation. Is that the best way of looking at that section?
I think perhaps that's, the way it was written at one time, and maybe that's the perception. I think operationally that's not what happens. I know, when you're working with any of the organizations and the OPP in particular, they come in and they provide assistance and they work collaboratively together. And quite frankly, that's the way all of policing does work. I just think it's, when you look at Section 9, it's going to be in that rare incident that you have something that is beyond the capabilities or capacity of a particular jurisdiction, and then maybe for that particular event, there needs to be some more clarity about what the roles are. But in the meantime, as Ryan had said, when we do this type of collaboration, there are, consistent with Morden, there are clear parameters that we have to address in terms of command and control and how things are going to operate. So it is happening already.
Okay, thank you. Professor Leprecht?
So there are other models in this country. So this is one approach. The other approach is in Quebec, where Quebec has a tiered policing structure. And my understanding is if, for instance, the equivalent protest had happened in Gatineau across the river, under the tiered policing structure, it would not have been the Gatineau police, because the tiered policing structure sets out competencies for police in light of the size of the police service. And so by default, the Sûreté du Québec would have had the operational command and control of a national protest. And so we either need to have a tiered structure or, as the chief and as Mr. Teschner have pointed out, need to have a clear governance set up for a for a joint force operation. And I think that was certainly one of the challenges that we saw.
Thank you. Any additional comments? So we have about 15 minutes remaining. Let's shift a little focus to the role to being a little more concrete about the role of the chiefs and the board in situations where there's a combined effort with multiple police forces and a whole bunch of other actions. So we talked a lot about some of the informal discussions and the trust and mature relationships, which is great. But what happens when that breaks down? Not just within a single police service chief and the board, but also when there could be competing boards, politicians of different levels, all those sorts of things. How do we deal with that? And in particular, how do we would describe the role of the chief and the board with respect to the declaration of emergency, whether that was done at the provincial level or the federal level? Should either of those parties communicate with the decision makers? Should they go, or should it only be through the board? Should the chief be talking to the decision makers when it comes to the declarations of emergencies? That was a bit of a rambling question. Putting it together. Professor Kempa.
I could just start the conversation by saying that I think It is always open to the chief of a municipal police service to have direct conversations with the provincial police service, whether that's an independent or contracted RCMP, if they require more resources. The board would be the first point of communication through later the Inspector General, but currently the OCPC, to the Solicitor General, communicating that they were in some kind of difficulty. But it is not likely the role of the board to make a specific request for the enactment of either the provincial emergencies legislation or definitely the federal emergencies legislation, simply to indicate that they are having trouble providing adequate and effective policing. And then when asked whether that's limited to resources or also if there's some authorities that are missing.
Any other comments on that?
I would, yeah, I would just agree that we have to come back to the statutory function and role of a board. Board is responsible to ensure adequate and effective policing. If through the information exchange with the chief of police, it becomes clear that the police service of jurisdiction can no longer provide adequate and effective policing, then that information should be transmitted to decision makers who are considering other options that don't exist within the world of the board or the chief of police. And that would be an informational input that hopefully they would consider in arriving at their decision. But that information should be, again, because it's a political decision made by elected officials as to whether or not to declare the emergency, that transmittal of information should come through the board. But importantly, the operational understanding would be conveyed to the board by the chief.
Sorry, that was also exactly my meaning. I may not have put it as clearly.
Okay. So is the board then the exclusive conduit in that situation? Or if an elected, the person responsible, the parties responsible for declaring the emergency want to phone up the chief of the police and have a conversation with them, is that appropriate?
I would suggest that it would be far better for both the chief of police of the day and for the elected official of the day not to do that, but rather to use the infrastructure and the framework that is set out. The board has that responsibility. The board is the chief's employer. The board should be informed by the chief about what's happening operationally, and then the board can engage with elected officials to have those conversations and bring things back. That's not to say that with respect to matters that are unfolding in a particular ward or a particular riding, there won't be conversations with a police officer who runs a division and the local elected official about what's happening within that particular pocket of a city. But when it comes to the overarching board duty to ensure adequate and effective policing, and when elected officials are getting interested and engaged because they're considering other options, there is a conduit here, and so we should use it.
Any other? Oh, Professor Leprecht.
I think from a board's perspective, there's also a question about, is there a plan? So you have to be able to develop a plan B and alternatives. You have to present those alternatives. You have to present the trade-offs of those alternatives to the board. So there needs to be confidence by the board that the plan can actually work, or for the chief and the board to come together and say that this is simply beyond our capacity, and so we're going to need someone else to take command and control of the situation. So I think we can't just, based on the event, suggest, oh, we better call for an emergency. We need to see what an effective plan actually looks like, and the plan that both the chief and the board can either have confidence in or say, we don't have the capacity to develop a plan, so we're going to need to scale this up, the classic sort of economies of scale, to a force that actually has the command and control capacity and the planning, logistics, intelligence capacity to run this type of operation.
Thank you. So one of the places we've seen consensus today is on the issue, the idea of an intermediary, right? Having a police board seems to serve important purposes and helps us reconcile some competing demands. So the RCMP doesn't, Professor Leprecht noted that only 4, he described it as kind of an aberration that there are these 4 that don't have the intermediaries, right? But another way of saying that is that the provincial forces and the RCMP don't have it, right? So are there other things like ministerial responsibility and the RCMP being at cabinet, right? They play a role there. Does that change the relationship such that you might not need that intermediary? Or does it suggest that those types of forces that are perhaps closer to ministerial control don't warrant that intermediary? That's a wide open question. Professor Pudister, you're smiling though, which I mean knows you have,
Sure.
You have an answer.
Well, perhaps I'm just reiterating what I said before, that I think a civilian board is essential here. I do think in the current configuration, the relationship between the public safety minister and cabinet could be altered. This could be a halfway step. We could think about the public safety minister and its relationship with cabinet similar to the attorney general in its relationship with cabinet, which would not be too far out of bounds because the solicitor general used to be part of the attorney general. And so when I'm speaking of the attorney general, I'm thinking of the role in such that they represent the views of the attorney general at cabinet, solicit views from other members around the cabinet table, but still hold that ultimate independence to make decisions. A model like that could be implemented for a solicitor general or the minister of public safety. But I suggest perhaps one other change would be necessary. Currently, we have a Minister of Public Safety that has a wide portfolio of responsibilities. Other jurisdictions, like New Zealand, for example, have a Minister of Just Policing. So perhaps in the scenario I'm suggesting, we have just a Minister of Policing that's fulfilling that duty. But I'll close in saying, I still think the more compelling solution is a civilian oversight board.
Okay. Professor Kempa, you're nodding along. Anything to add?
No, just that, in fact, that close relationship with the commissioner being a deputy minister has been specifically identified as a source of a number of the problems facing the RCMP, in that whether there is real or perceived political pressure on the deputy minister / commissioner, there has been a tendency to manage upwards to anticipate the needs of the minister in ways that may not reflect the needs, the downward needs of the organization. That was, of course, the main conclusion of the Brown report.
Professor Leprec.
There's considerable symmetry in Canada with regards to the expectations attorney generals have and lay out for the RCMP. So they are quite detailed, and the most detailed, to my understanding, in British Columbia. In other jurisdictions, there is very little in terms of sort of the overall expectations. And so I think there's probably some of the expectations and the relationship also by the Ontario and Quebec attorney generals and the relationship with the RCMP, because of course in both provinces the RCMP normally only does federal and national policing duties. And so are there circumstances where the attorney general will need to make those federal units essentially request that they become operational units, because if you're flying in people from British Columbia, it's going to take you a very long time to surge capacity in Ottawa. And so I think clarifying that relationship of the federal and national policing capabilities, and when that federal and national police service provides effectively contract quasi services, even in Ontario and Quebec, that relationship with regards to the expectations from the attorney generals needs some clarification.
Thank you. Let's just being mindful of the time. Would the panel have any comments with respect to the appropriateness of police involvement or participation or even information in negotiations between government actors and the protesters? So in a public order context where the government is, or actors in the government are seeking to have negotiations with the protesters, talking about mediating the problem, do the police play a role there, the police chief, or intermediaries lower in the police?
Well, I see you're looking at me.
Sure.
I would.
Chief Raber.
Yeah, the only comment I would make is that should never happen. unless it's done in conjunction with the police operation and with the full knowledge and support of the police to help to come to some type of peaceful conclusion or perhaps, I mean, it's done every day. We have 17, 18 protests every weekend in Toronto. And the first thing we do is we meet with the protest leaders. And we talk to them and say, no, you can't shut down all the city, but maybe we'll facilitate a march around these locations and we'll help you do that. And we come to that. And I think that really, at the end of the day, that's what, by going to that level of government individual to help, it's obviously going to be a more significant event, but you're going to try to accomplish the same thing in conjunction with the police operation. So I think they need to be done in tandem if they are undertaken, and there's agreement that they should be done.
Okay, thank you. So we did have a specific question for Professor Pudister. You spoke early on about the significant challenges faced by police oversight agencies, and there was a question about whether you could elaborate on those challenges.
Sure. So my area of research on this is mostly on Ontario, but thinking about the jurisdiction of these oversight bodies and the SIU in particular, is what I'm going to talk about. And it's useful to focus on the SIU because that's the model that's been exported across Canada. And I think one of the biggest challenges in relying on an oversight body like that to provide accountability is that they have actually a very limited jurisdiction in which they can investigate. The SIU in particular is involved in serious injury, death, allegation of sexual assault, or the discharge of a firearm. Beyond that, there are other accountability mechanisms that come into play, but their jurisdiction is actually very limited. And I think the public has a very poor understanding of what they can actually do. The other significant area of limitation for the SIU and for many oversight bodies is that they don't have the ability to engage in systemic review, such as like we're having right now, to examine larger issues, to think about connections between particular events that they've investigated, or perhaps, you know, if there's repeat issues with a force, the director can issue a letter to the chief, but they don't have the same powers to compel a full review. So their role is very limited in that they are reactionary only, very important mechanism of oversight, but are very limited in the ability to provide any, you know, guidance going forward beyond criminal investigation.
Any other comments?
Sorry.
Sure, yeah, Mr. Commissioner.
If I could, I would just say certainly the SIU's jurisdiction is as limited as the statute says that it is. It's a criminal law jurisdiction. There are other players on the landscape that we have to also take into consideration. Of course, boards, which we've been talking about, which have a unique ability, actually, almost an unlimited ability in some respects, to review a number of issues, both with respect to complaints that are being brought forward because they have a statutory mandate to review the administration of the complaint system by the chief, and particular issues that relate to their policies or the implementation of their policies. A capacity, though, that requires, again, back to my recommendation, professional resources to actually have some oxygen. These are all great things in theory, but as a practitioner, I can tell you that not all boards across this country are in a position, in fact, very few, very, very few, would be in a position to actually carry these things out. And so if we're serious about them, then we need to appropriately invest in them.
In our final minute, does the panel have any concerns about, so we've been very suggesting that police services boards do provide an important function. Are there any problems with that where we might have some reservations about having that kind of model at the federal or provincial level? Or is it all goodness and light?
Well, no. As Ryan Teschner is alluding to, without proper resources, police services boards have not had a record of untrammeled success across Ontario or Canada, for that matter. And in fact, for example, in the United Kingdom, they've moved away from the police authority model, which is the same essentially as the police services board model for an elected local body, that through the theory of being elected has even greater legitimacy to intervene in operational type matters and so forth. So it is a question of whether, to evaluate whether the Police Services Board model is a good one for Canada, it's a bit unfair to look at the track record on the basis they've never had the training, resources, or clear explanation of their authorities to actually carry out their functions.
Any other comments? Nope. We're 1 minute over time. Oh, sorry, Professor Leprecht. Briefly.
Just to point out that ultimately it's up to the people to decide. We live in a democracy, and the people create the framework under which police, boards, governance, and so forth transpires. And so we can blame police, we can blame boards or whatever, but ultimately the importance of the commission and the inquiry is that it's a question of are the frameworks appropriate and are they fit for purpose? And the nature of the discussion today suggests to me that they are not entirely fit for purpose for the 21st century.
Thank you. That's a good point to end on.
Okay, well, thank you to all the panel members. It was very interesting. Made a lot of recommendations. Some of them may find their way into a report. I'm not quite sure which or whether, but certainly you've been very helpful in sharing your knowledge, sharing your expertise, and sharing your thoughts. It's very appreciated. As always, I learn a lot, and I have learned a lot today thanks to you all. So thank you to all the panel members, and special thanks to you, Professor Baker, for your moderation and I'm sure preparation for this, as everyone I'm sure has put a lot of time, and probably you a little bit more. So thanks again. We're going to adjourn until 2 o'clock when we have another panel.
The commission is in recess until 2 p.m. La commission est levée jusqu'à 14 heures. He's warmed up now.
Nice to meet you.
The commission is reconvened. La commission reprend.
Okay, well, good afternoon to all those who are online and to our guests who are here to debate another subject. This one more related to interjurisdictional responses to protests and emergencies. Alors, bienvenue à tous.
Welcome to all. This session will deal with interjurisdictional relationships regarding protests and emergencies, a topic that drives us nearer to the various questions we have to address regarding the emergency measures. So thank you all for being here. And without further ado, I'll present to you the moderator for this session, Jocelyn Stacey, professor at the Howard School of Law at UBC. So, you have the floor, ma'am.
Panelists.
Wonderful. Thank you. Good afternoon, Commissioner. Good afternoon, everyone. I'm very privileged to be here today. Thank you for having me and for that introduction. And we're very lucky to be joined by experts who are both online and in person. And so in person here with us today, I want to just acknowledge that we're meeting here today on unceded Anishinaabe Algonquin territory, and we've got two experts who are joining in person. So next to me is Mr. Jack Lindsay, Associate Professor in Applied Disaster and Emergency Studies at Brandon University. We also have Mr. Ryan Teschner, Executive Director and Chief of Staff of the Toronto Police Services Board. And we have three experts joining us online, so thank you for joining us from a variety of locations around the world. We have Dr. Dwight Newman, KC, Professor and Canada Research Chair from the University of Saskatchewan College of Law, Dr. Judith Sayers, President of the Nuchalnath Tribal Council and member of the Hupatchesett First Nation, and Mr. Cal Corley, who is the Chief Executive Officer of Community Safety Knowledge Alliance and a former Assistant Commissioner of the RCMP. So thank you all for joining us this afternoon. As the Commissioner has said, this is a panel that focuses on interjurisdictional responses to protests and emergencies. The experts that we have with us today are going to discuss topics that fall roughly within sort of three themes. So the first being the roles and responsibilities of different orders of government in responding to protests and emergencies, or public order events and emergencies. The second theme will be more focused on mechanisms for consultation, coordination, and cooperation between different levels of government and between agencies. And then finally, we'll focus on the Emergencies Act itself and looking at the appropriate roles of multiple levels of government in the use of the Federal Emergencies Act. So I'm going to kick us off with some of the questions that we have discussed, focusing on. We're going to start by laying a bit of groundwork in terms of responsibilities of different orders of government. So Professor Newman, I'm looking to you to help us lay a bit of the groundwork here by starting us off with the question of what is the federal government's constitutional role in addressing emergencies, and how did the convoy events engage matters of federal jurisdiction?
All right, good afternoon, and I'm very pleased to be part of this discussion. I'm fortunate to be joining from London, England today, and just glad that the Zoom connection could work to facilitate participating. I'll start off just briefly by saying that I don't want to speak too directly to the convoy itself, so much as to speak about the issues of jurisdiction on emergencies generally, in the context of the forward-looking nature of this roundtable. The federal jurisdiction in relation to emergencies can come from different sources, and the term emergencies is potentially broad and potentially multifaceted and used in different ways in different contexts. But just thinking in general in terms of a federal jurisdictional role in the context of emergencies, that can come from sources of federal authority under Section 91 of the Constitution Act 1867, areas where the federal government has jurisdiction, such as on matters of international trade, the international borders of Canada. There's federal jurisdiction, and to the extent an emergency engages those contexts, there could be straightforward federal jurisdiction. The same could be said of something like the National Capital Region, in terms of there being a recognized area of federal jurisdiction there. At the same time, the federal government can also take up jurisdiction that it would not normally have in the context of an emergency, making use of the emergency power branch of the peace, order, and good government power held by the federal government. And that's been interpreted in some case law to allow the federal government, in the context of a temporary situation where it has made a formal declaration of an emergency, and there's controversy on just how to describe it, but where there's a sufficiently strong basis for that determination of there being an emergency, with that being defined differently in different cases, the federal government has constitutional jurisdiction in relation to something that normally would be within provincial jurisdiction. Of course, provinces have normally much jurisdiction over matters of local concern, matters of property and civil rights, many things that would relate to emergencies in the broadest sense of the term. And so this POEC emergency branch power is significant. The Emergencies Act is a federal statute that doesn't necessarily use all of the powers of the POEC emergency branch, but that uses that POEC emergency branch in some circumstances. Some parts of the Federal Emergencies Act relate to matters more within federal jurisdiction. An international emergency or a war emergency would be within federal jurisdiction. Something that's a public welfare emergency or a public order emergency might normally have been in federal jurisdiction or provincial jurisdiction, or a bit of a mix of both. And the Emergencies Act says that in some circumstances, the federal government may take up jurisdiction there, presumably relying upon the POEC emergency branch if the matter would normally be within provincial jurisdiction. The Emergencies Act shifts power from the legislature to the executive at the federal level, and it shifts sometimes jurisdiction temporarily from provinces to the federal government based on a set of balancing mechanisms within the Act. including a number of provisions on consultation with provinces, requirements of provincial consent in certain circumstances in sections 14 and 25 of the Emergencies Act, and various matters. I'll just say, in the context of emergencies where federalism is at stake, federalism can be affected by responses to emergencies, whether symbolically or in practical ways that resound over time. And certainly the invocation of the War Measures Act in the context of the October crisis, obviously predecessor legislation, had some long-term effects on federalism and issues related to the federal-provincial tensions in the country. It remains to be seen what will happen out of the 2022 situation. The other thing I'll say, and this probably feeds into other topics though, is simply that the Emergencies Act has not been updated in light of Section 35 rights, or in light of the United Nations Declaration on the Rights of Indigenous Peoples Act, Section 5, which obviously requires measures at the federal level to ensure that the laws of Canada are consistent with the UN Declaration on the Rights of Indigenous Peoples. That's a topic I imagine we'll be getting more into. The federal government has ways of using some of its jurisdiction more than it has without using the Emergencies Act necessarily. And to the extent that the convoy situation highlighted vulnerabilities of the National Capital Region, I would just say the solution isn't necessarily solely in terms of modifications to the Emergencies Act, but might involve the federal government taking up more of its jurisdictional potential in the context of the National Capital Region through legislation just on how the National Capital Region is regulated and policed. And that could be something else to be considered apart from the Emergencies Act. So those would be a few comments in response to that question, and I might leave it there.
Thank you very much, Professor Newman. I wonder if, just to complement that nice sort of overview of federal jurisdiction, we might get a bit of insight from other experts about sort of what those constitutional roles look like on the ground. And so, Mr. Teschner, would you like to weigh in on that, maybe briefly? And maybe just I'll give a reminder to everyone to speak slowly if you can, so that our interpreters can keep up.
Thank you, Professor Stacey. My perspective is going to be a bit more local in nature because at the end of the day, in responding to an emergency, regardless of who makes a declaration, the policing that needs to be responsive to that emergency, generally speaking, happens locally. And so it doesn't necessarily mean, of course, that other interests, whether they be provincial, federal, or both, aren't engaged. But my message here today is that effective coordination in responding to an emergency, assessing whether or not to invoke the act or make a declaration, requires us to really take the lessons that we should learn from cooperative federalism. And that also includes giving a zone for municipalities as appropriate through the provinces, but importantly, for police services boards municipally that have a statutory role to play when it comes to the adequacy and effectiveness of policing in that jurisdiction, which includes emergency response. And so making sure that there is a mechanism through which police boards that are most impacted can be part of that consultative process, I think is essential. I think the question that I was wrestling with in preparing for this is how can any entity determine when something engages a broader interest beyond its own? And if so, what does that mean for the different orders of government? And so I think one of the ways that this commission, Mr. Commissioner, could be helpful is perhaps in clarifying, based on what was just said, clarifying those triggers or those thresholds and getting perhaps a little bit more granular. The approaches to escalation need to be better set out. And that doesn't necessarily mean that they all have to be set out in legislation, but they have to be set out and they have to be understood so that we ultimately can move towards a modern, multi-agency governance framework that defines roles, responsibilities, escalation methods, communication protocols as an emergency is unfolding and while it is unfolding. Ultimately, so that these responses don't unfold in an ad hoc manner. And everybody knows, to borrow an Abbott and Costello analogy, who's on first.
Thank you. Okay, so we're quickly getting the picture of emergency management being a multi-jurisdictional endeavor. And so one area of jurisdiction that we want to bring into the conversation is the role of Indigenous jurisdiction in protests and emergencies. And President Sayers, can I turn it over to you to speak to that?
Yes, thank you. Judith Sayers coming to you today from the Coast Salish territories, and I'm pleased to be able to talk to you about Indigenous jurisdiction. And I'm going to talk about First Nations in particular. Indigenous people, as you know, includes Métis and Inuit. My expertise is First Nations. So I'm going to talk about First Nations. And First Nations have been here since, in our language, Ichmut, or time immemorial, longer than any mind can know. Our governments have been in place that long as well, and we're the first governments on these lands known as Canada. We had in place our own laws, protocols, communications, and looked after and protected our own lands and resources. All of the lands in Canada have First Nations title on them. They are within the territories of the over 633 First Nations across this land. Many different kinds of First Nations. There are a number of treaties, which are, a lot of them are historic and shared their land to the depths of the plow. There are Aboriginal title lands in British Columbia, which have never been subjected to treaties, war, cession, or discovery. Then there are modern treaties where the issue of lands and laws have been negotiated. Yet, as important as First Nation governments on these lands, the title and the role of First Nations in Canada, neither the Emergencies Act or the Emergency Management Act mentions First Nations as governments. Everyone else gets notice, the provincial governments, municipal, but not First Nations. So there's no formal role to play when emergencies arise. Yet when emergencies happen, it is First Nations' lives at stake, their lands, resources, and their ability to carry out their Section 35 protected rights. The danger, of course, in not mentioning First Nations jurisdiction in the Emergencies Act is that other governments would assume authority over the lives and lands of First Nations without their consent and without the proper background and knowledge, and usurp the authority of First Nations. As a first recommendation, the federal government must amend the two Emergencies Act to include First Nation governments. This amendment process must be inclusive of all First Nations in Canada as to what role First Nations will play in emergencies, how they are involved in decision-making, what information they are provided, ensure that their people, rights, lands, and resources are protected. Canada has now in place a law called the United Nations Declaration on the Rights of Indigenous People Act, and it's now law and needs to take into consideration and make their laws consistent within their emergency law. And so this is something that has to take place because this is now legislated. And in particular, Article 30 of UNDRIP talks about military activity shall not take place in the lands or territories of Indigenous people unless justified by relevant public interest or otherwise freely agreed with or requested by the Indigenous people concerned. And states shall undertake effective consultations with the Indigenous people concerned through appropriate procedures, and in particular through their representative institutions prior to using their lands, territories for military activities. So if by any chance an emergency, the military is called in, we have to define what does that procedure look like? What say do First Nations have in that? While Oka was not considered an emergency, no one will forget the tanks rolling onto the Mohawk lands, called in to stop the First Nations people from defending their lands. UNDRIP and the changes that need to be made to federal law and policy to reflect these commitments must be done. And it must be consistent with all the articles in UNDRIP. there is a duty on the federal government to report to and engage First Nations. First Nations need to be able to help define what an emergency is, and not just a decision of the federal government. We must be able to determine what is critical infrastructure and services. Often remote or small communities are not considered critical infrastructure because it only affects a small number of people or a smaller community that is critical to them. During the big fires in British Columbia a couple of years ago, I was meeting with a minister and I got a call from one of our First Nations, and the fire was just coming down the hills quickly to their community. I had to plead with the minister to send in helicopters and to consider that critical infrastructure. But that wasn't what they had thought. But thankfully, they did send in the helicopters to start the fire. These are the kind of critical situations that we need to talk about. Or during the flooding in British Columbia, where gas wasn't being brought into the province due to all of the transportation corridors being shut down, we were all limited to 30 liters per car. Had to negotiate with the government to increase that for our remote communities, because you can't get very far in our communities on 30 liters. You can't get in to get your food and necessary supplies on that. So it's very critical that there is an amendment to the Emergencies Act and Emergency Management Act so we can clearly lay out what is needed in First Nations communities. Thank you.
Thank you, President Sayers. So I think maybe what we should do is move on now that we have this sense of the different jurisdictions that are involved in emergency management to talking about mechanisms for facilitating consultation, coordination, and cooperation, and see if we can get into some examples of what kinds of mechanisms have facilitated successful interagency and intergovernmental coordination in past emergencies. And so I'll turn it over to Mr. Teschner to start us off with that, and then we'll bring in some others as well.
Thank you. People that I work with will understand me when I say that I use a Pee Wee soccer analogy to talk about how I view emergency management sometimes. And those who are intimately familiar with it may not quite see it that way, but I think there are many, including those in government, who perhaps don't understand that there are different responsibilities at different levels and different methods of engagement. And so to some, I think it does seem a lot like Pee Wee soccer, where the whole team is chasing the ball and no one is respecting the position that they're supposed to play. I think in the context of emergency management, we have to avoid two things. We have to avoid the assessment and response depending on personalities, as opposed to structure and good governance. And we have to avoid what have been known as stovepipes or silos to information sharing. I believe that we need to update, to some extent, our multi-jurisdictional infrastructure and approach to better align with the principles of cooperative federalism I mentioned earlier. In the context of policing specifically, there are some examples where this is done well operationally. And if you think back to the G20 summit and to the 2010 Winter Olympics, you did have the RCMP, the provincial police of jurisdiction, at least in the case of Ontario, and municipal police services in Toronto, in an integrated security unit where there was plans that were co-developed, co-designed, where everybody understood more or less. Of course, the Morden report spoke to some of the gaps, but where they went in at least among themselves, understanding who was responsible for what, and everybody understood how the information was supposed to flow. It facilitated the coordination of both the interjurisdictional planning and response to those public order events and emergencies. Of course, lots of lessons to be learned from the Morden report, but that was the same structure that was used in the 2010 Olympics. In the context of national security, there are integrated national security enforcement teams that operate, with the RCMP being given primacy because it's matters of national security, where you have federally led investigative teams that are comprised of the RCMP, Canada Border Services, Citizenship and Immigration, CSIS, but also provincial and municipal police services. And so even though the RCMP have primacy, interwoven within the relationship is a joint forces integrated environment where police share the operation responsibilities that flow from the national security needs, and the decision-making process is structured in a more shared way. My suggestion here is that emergency management could potentially benefit from an upgrading, if you will, to its governance structure when it comes to interjurisdictional responses. And I take some of my inspiration from the UK Emergency Response and Recovery, a 2013 document that provides non-statutory guidance that accompanies the UK Civil Contingencies Act. And I think that a modernized emergency governance structure would have 5 key components. The first would be, well, the premise would be that you would have an interjurisdictional coordinating group, a superstructure of sorts that would be designed and that would operate based on 5 elements. The first is an understood structure and hierarchy with a sufficient role for, yes, the local level, and to President Sayer's point, the First Nations and Indigenous communities that are impacted by that particular emergency. Clear roles, clear responsibilities, a clear mission statement as part of that structure. Each organization or entity would be represented and would retain their own command authority, but would exercise control over their own operations in a coordinated and facilitated fashion. It could rely on discussion and consensus for the most part, and it would allow for a common operational picture and more efficient response and deployment when you have multiple levels or orders of government involved. It would promote a full information exchange between the partners, where no local entity that is impacted is placed at a disadvantage. And of course, it would help ensure interoperability. The second is to include, yes, the formal actors I mentioned, but also informal actors. A hybrid structure that would involve outside of government actors that may be impacted or may be able to lend a hand in terms of the development and implementation of the response. And the 2014 Ebola outbreak in Sierra Leone was an example where that kind of structure was used to mobilize community groups, volunteers, religious groups, all involved in the response to that particular emergency. The third, and I'm sure Cal Corley will speak about this, is the importance of joint exercises and trust building through those exercises. That this interjurisdictional coordinating group should engage in long-term planning among the partners, but also modeling, tabletopping, and exercise in advance of any emergency so that they understand better how to operate within that context and so that they know what to do when you're in the gray zone of a plan that doesn't necessarily speak to precisely the circumstances that you're facing. The fourth would be a transference of duties as appropriate. Emergencies generally cause people to revert to institutional lines, but that can sometimes cause fragmentation and doesn't necessarily result in the best resource being deployed to address that particular circumstance. So looking for opportunities within the structure to properly and with consent redistribute duties in a way that still respects jurisdiction, but is premised on a functional or capacity approach. And the fifth is communication and the importance of the structure allowing communication to work over all phases of an emergency to ensure that the multi-agency approach with respect to communication functions well and that it satisfies the communications needs of all of the people around the table because those needs may be different. I would even urge exploring some kind of national communication mechanism for law enforcement agencies that balance the intragroup, the intergroup, and public communications that law enforcement often have to engage in the context of emergencies so that we minimize confusion, optimize consistency, and make sure that everybody has the ability to get a message out to the public. Thank you.
Thank you. Mr. Corley, do Do you have some examples that you'd like to add around coordination, cooperation, consultation?
Yes, indeed, and thank you for that, Jocelyn. And thank you, Commissioner Rouleau and team, for inviting me to participate in today's panel again. As mentioned, I'm a former assistant commissioner at the RCMP with experience some years ago in both protective operations and national security investigations here in the National Capital Region, as well as time spent on secondments at both Public Safety Canada and at the Privy Council office within the Security Intelligence Secretariat. I'm calling in today, unfortunately I've got a bit of a chest cold, calling in from the National Capital Region and acknowledge being on the traditional homeland of the Algonquin Anishinaabe Nation. I've been asked to pick up on a couple of areas of focus today, principally around picking up on my comments yesterday at the roundtable on public protest policing, with particular attention to three areas: how to institute stress testing and multi-day, multi-agency training exercises that support an effective ecosystem response to public order events and emergencies. Number two, to pick up on, and it actually picks up nicely on Ryan's comments a moment ago, about how major case management can work to ensure coordination while allowing latitude to address a local context. And finally, how the Security Offences Act and the Foreign Missions and International Organizations Act operate in practice insofar as police operations and cooperation are concerned. I'll turn first to joint agency exercises. I'll try not to be too repetitive to what I said yesterday. But in my view, it should have been clear yesterday, but I'll be explicit. This type of training, in my judgment, is a critical success factor going forward. And I'll again note Ryan had that in his proposed 5-point plan. These exercises in the National Capital Region used to be commonplace during the 1990s. Similar ones, of course, were also instituted in advance of events such as the 1997 APEX conference, G20 and other planned events. But that's a distinction with those in the NCR. These were a standard practice. They were not in preparation for any specific event. These exercises were often 2 days or so in duration, and they were coordinated at that time by the then Solicitor General Department, now Public Safety Canada. These are not alternatives to other local training or educational efforts, including tabletop exercises, as important as they are. And as we've heard today from Chief Raymer, that often much of that local training can be rather piecemeal in many cases. These exercises typically involve the full range of police agencies in the NCR on both sides of the river, CSIS, Public Safety Canada, PCO, and relevant departments and agencies from the City of Ottawa, City of Gatineau, and the Province of Ontario. In a contemporary context, of course, as I mentioned yesterday, these should also involve Indigenous government representation, as well as the private sector actors. Both of these issues, again, are a matter of record from yesterday. The principal focus on these exercises back when I was involved was largely around the full range of national security issues and served to stress test all aspects of the enterprise, from governance, policy making, information sharing, and other protocols, leadership, tactics, and operations. As I mentioned yesterday, assuming that we had a national and provincial standards in place, supported by appropriate agreements between governments and as between governments and as between police agencies, it's crucial that these standards and elements of those agreements be stress tested and practiced, because even the best laid plans typically survive first contact. So this is really around getting around that to ensure the effective application of previous intent. Not only did these improve individual and collective capacities and capabilities, but it really helped iron out kinks in the system, developed a good understanding of agreed to procedures, improved information flows and responsiveness, nimbleness, and allowed leaders and practitioners from these different agencies to develop closer relationships, something that's highly important when the rubber hits the ground. As mentioned yesterday, I've learned recently that such in-depth exercises have not been undertaken in the National Capital Region in the manner that I've spoken of for some years. I can't speak to what's happening in other centers across Canada, but it certainly speaks to the NCR. It would seem to me that looking forward with the realities of startup limitations, that a training regimen, if it was to be reignited or reinitiated, should first focus on the National Capital Region and then build outward to other major centers across Canada based on ongoing risk scanning assessments. In the absence of such exercises, the risk is that formal standards, protocols, and agreements will fall short when it comes to implementation. So what would be required to initiate such training exercises? I'd obviously defer to legal colleagues, but it strikes me based on my experience that initiating such an endeavor should not require legislative or regulatory change. Rather, it would require an informed policy decision supported by a somewhat modest funding envelope to enable Public Safety Canada and/or Emergency Preparedness Canada to consult, develop, and implement appropriate and ongoing sustainable regimen of joint training and joint learning. A commitment from the agencies and departments to participate in such exercises is also important. Today, certainly within policing, with the challenges on finite police resources, it's important that this be seen as something that's important for the collective good, and that resources be assigned to these types of exercises. The other area that I should touch on briefly that I didn't touch on yesterday has to do with police military training, joint training as pertaining to aid to civil powers. This is another opportunity that today, from my understanding today, only a limited number of mid-level and senior police leaders have occasion to undertake jointly with their military counterparts. And the experience I had in that type of joint training with the military was invaluable, again, in understanding their capacities, their capabilities, and logistic superiority in many cases is of tremendous value and probably an area that should be explored. Just closing off on this section, if it was fully implemented, I'm confident, based on my experience, that such a regimen of ongoing joint learning would serve the security and community safety ecosystem and our communities well for years to come. I'll turn now to major case management. I was asked to pick up on comments yesterday in terms of the MCM model as an exemplar, I suppose, for lack of a better term. And I think picking up on Ryan's comments a few moments ago, really what he described in his proposed five-point plan really is what major case management model is about. Like major public order events and emergencies, major criminal investigations are typically complex and multifaceted. Those investigations often cross multiple jurisdictions and involve more than one investigative agency, in many cases, many investigative agencies. The stakes are high. The cost of failure, of not following proper methods or standards and not respecting evolving jurisprudence can result in breaches of charter rights, wrongful convictions, and other miscarriages of justice. Major case management provides a flexible yet standardized framework and supporting tools that enable skillful leadership and structured coordination required of these complex matters. Emphasizing accountability and a multidisciplinary approach, major case management provides sound structures for the investigation, including, importantly, a centralized leadership and coordinating body, similar to Ryan's first point at a national level as it pertaining to the present matter. Clear and unambiguous standards, standardized training, and common technologies. It establishes clear lines of responsibility and decision-making. It supports the idea of unified, inter, and multi-agency leadership. Rigorous approaches and infrastructure, in the case of Ontario, for example, even the technology that's used across police services in Ontario to support major case management is one particular software. I could go on with other benefits or what major case management intended to do, but suffice to say, it's the centerpiece of effectively undertaking these types of complex endeavors. The province of Ontario developed its regulation and corresponding major case management manual, which is administered and maintained by the Solicitor General in the wake of the Paul Bernardo investigation. British Columbia, in its case, its particular framework, it evolved from the Missing Women Commission of Inquiry. Note in both of those cases, this was an outside-in directive to policing. And the evidence over, big changes in policing tend to come from the outside. The evidence of that is clear. MCM is a proven technology, national standards that are overseen by an advisory group of senior police experts, and the Canadian Police College's Major Case Management course is the standard for training in Canada. How might a comparable methodology support more effective responses to public order emergencies? Well, I could walk through an adapted list that's based on the major case management model that I just referred to. But I think it's pretty clear to anyone listening that that transference, and in the spirit of time, I won't go through it, but it's pretty clear to me that there's a really good example there of how this can be done much more effectively. Finally, I'll turn to the Security Offences Act and the Foreign Missions and International Organizations Acts that I was asked to speak to. The issues here are how relevant aspects of these pieces of legislation operate in practice, and what roles do other police agencies, that being non-RCMP agencies, what roles do they have when these acts are invoked? Excuse me. The implication under each act is quite similar, but for the purposes of brevity, I'll speak only to the Security Offences Act. Of course, this act deals with the enforcement and investigation of certain national security and related offenses as currently set out in Section 2 of the CSIS Act. When the SOA is invoked by the Attorney General of Canada on the belief that an offense under the act has been committed or likely to occur, Section 6.1 stipulates that the RCMP will assume lead responsibility for an investigation. Importantly, though, subsection 6.2 deals with the practical reality of the conduct of these investigations. In essence, that subsection states that to facilitate consultation and coordination in relation to the undertaking of related duties, the Minister of Public Safety and Emergency Preparedness can enter into agreements with the provincial governments affected. Experience has largely been in practice that the RCMP recognize that they cannot successfully undertake these types of investigations on their own. At minimum, they often lack all forms of local knowledge. But local agencies also, beyond just specific local contextual knowledge, they also bring tremendous value in terms of complementary capabilities and know-how that can be beneficial to the investigation, hence the greater good. Now, in practice, this is part of why the regimen of stress testing standards, protocols, and such bilateral and multilateral agreements that we've spoken of become highly important. The transitioning of leadership in such instances, and I suggest here, and I think Ryan touched on it as well, whether we're speaking about the implication or the application of the Security Offences Act or the Emergencies Act, these tend to be investigations that evolve, and that transfer of leadership or transference of responsibility and accountability often occur at times when tensions are often already stressed by the very nature of the incident that's at play and the overall situation at hand. So these can be awkward at the best of times. Beyond that, personalities and egos, both institutional and individual, cannot be discounted. So having arrangements formalized and in place that are tested, exercised earlier as a matter of course can pay huge dividends in terms of that seamless transition. One example yesterday was in relation to back in 1986, hostage taken at the Bahamian High Commission in Ottawa. And of course, this predates these types of exercises, but it really featured two senior police leaders from two of our organizations on the sidewalk engaged in a heated debate over who had jurisdiction. We don't need, that doesn't endear trust or confidence in policing. and something that can be avoided through mechanisms such as have been mentioned. And now finally, just would like to come back on a comment yesterday as well. In Quebec, the province of Quebec, of course, with its 6-level model of policing, has largely overcome these issues. And it was referred to earlier today, I think, by Christian Luprecht. But I recall a conversation with the former chief of the Gatineau Police, Mario Arel, and speaking in this example, it was about murder investigations. So if his team is at a murder scene and they're the police of jurisdiction, but once they realize, perhaps because the amount of drugs, money, weaponry that's there, that this involves organized crime, they no longer have jurisdiction on organized crime investigations. And they are now protecting a crime scene, and the Sûreté du Québec become the police of jurisdiction on that investigation. The 6-level model in Quebec has been in place for years. It took a bit of time early for this to become normalized within police culture. But today, if I listen to police leaders in Quebec, they like it. They don't have to prepare for events or investigations that are beyond their reasonable capacities based on the size of the police agency. And they can prepare and do very well within the scope of things that they can do. So clear, unambiguous models and protocols have become just part of the way business is done in that regard in Quebec. Thank you for the opportunity to share these views. And Jocelyn, I look forward to the rest of today's conversation.
Thanks, Mr. Corley. It's great to have those examples. And President Sayers, I wonder if you might like to join in on this part of the conversation. Any examples that come to mind for you of successful coordination, cooperation between First Nations and Crown governments?
Thank you. Yes, I would. Judith Sayers here. One of the government-to-government memorandums of understanding that we reached was during the COVID crisis. And as governments, we weren't able to make decisions because critical data was being kept from us. We didn't know how many COVID cases were in surrounding communities. We didn't know if it was okay to tell our members to go into those communities because we had no idea of how many COVID cases. So we went to the provincial government and we said, hey, we really need to know this. It took us 7 months to negotiate that, which, COVID was still relevant. So it's important that these kind of protocols be entered into prior to, but in order to make decisions during emergencies, First Nations need to have access to information. And I know that there's confidentiality, and we did deal with confidentiality in our agreement, but it was important to do that. It's also important in this data to ensure that we have specific data for First Nations on reserve, off reserve, if we possibly can have that information. And so any kind of information happening during an emergency makes it important to First Nations so they know where the fire is coming from. Of course, flooding happens pretty quickly, but just knowing the information that is required so we can manage emergencies, we can manage what is happening, our responses. Another example would be Canada closed its borders to the US. No doubt it needed to be done, not questioning that. But by doing so, it also separated our communities that are on both the Canadian and American side. And had we been able to have conversations with Canada, we might have been able to put in some provisions to allow that kind of cross-border activity. Maybe not. But I think it should have been talked about. And then Canada opened its borders again and let people come in. And in the waterways in particular, some of our communities are remote on islands, and pleasure crafts were coming in and, of course, trying to enter the communities. And, we're trying to exercise jurisdiction and asking people to stay out. And on the waterways, it was difficult. So, and that's Transportation Canada kind of people that we're working with. So I think if we can look forward into the future to see what it is that we need, what are the kind of conversations that we need to have in order for us all to respond to emergencies, what roles can we play? And I think the government-to-government coordination needs to be defined. It needs to be put into the Emergency Act. How much time does First Nations have to respond to emergencies? Provinces get 7 days. Should be the same for First Nations. I think that in order for us to be able to do things properly, we need to be coordinated with, for example, bring in the military to help with forest fires. It's become a common issue in British Columbia. And we should, and I think Ryan talked about this, we need to have that communication, that coordination. We're all working for a common cause, respecting each other's jurisdiction and abilities to do that. I think financial aid is also something that can be negotiated. What happens after a national disaster? How do we rebuild and replace what was destroyed or damaged? One of our communities that was in a fire that was destroyed still hasn't been rebuilt. One of the other tools that we have is reconciliation and the calls to action. There is a bill C-29 before Parliament right now to put in place a body to deal with reconciliation. And having these kind of understandings, dialogues, agreements with federal government is all part of reconciliation. Reconciliation is about making things in the past right and having been kept out of emergencies, not having a good role needs to be set right. We need to have those conversations. It's a lot of work. It's a lot of work that's ahead of us. Yes, I definitely agree to that. But it's something that has to be done. I also think the federal government needs to encourage and support protocols between First Nations and the RCMP in times of emergency. How do we work better together? What is the understanding? And I realize this wasn't an emergency, but we all watched in British Columbia, northern British Columbia with the Wet'suwet'en, the RCMP just went in and took down all of the land defenders camps, and it wasn't done properly. Can we not find better ways to work together so that we can avoid those kind of situations? And, that's just one example of, what people might call a protest. Other people are calling them land defenders. But, these are the hard conversations we need to have. Yes, emergency or federal jurisdiction. But yes, First Nations have rights, and First Nations need to be able to manage what happens to those emergencies in our lands, and we need to have capacity built. How do we fight fires? How do we fight things on the water if we don't have the proper resources to do that? And so those are, capacity building is a huge area that we need to enter into protocols with. So I thank you for your time.
Thank you for that. I'm hearing a lot of sort of consistency in what the experts are saying so far, right? The importance of communication, entering into agreements and protocols, training and resourcing. And so in some ways it's really no mystery, right? These things all have to happen outside of the actual emergency response. Professor Lindsay, we haven't heard from you yet, and so I'm hoping to bring you into the conversation here to hear a little bit about what tools the federal government has and maybe where there are gaps in terms of what's available outside of the Emergencies Act, maybe to do some of these things that the other experts have set out for us already.
Thank you, Professor Stacey, and thank you very much, Commissioner, for having me here. I want to start, though, by saying it's important to note that emergencies are not crimes. Hazards are not criminals, and our emergency management practices are far broader than policing. While this use of the Emergencies Act was focused on a security issue, we should not frame our future as a policing function. The Emergencies Act is only one tool in the National Emergency Response Kit. It is a crucial component of the rule of law. These laws at the provincial and federal level allow citizens to know in advance the range of powers and the limits on those extraordinary powers that governments will exercise during emergencies. The Emergencies Act is also not the only outdated tool in what has become a somewhat rusty toolkit. Thank you. It was passed in 1988 alongside the Emergency Preparedness Act. That act, for the first time in law, set out how the Government of Canada would organize and undertake its emergency management responsibilities. It created Emergency Preparedness Canada, answering to its own minister and reporting annually to Parliament, a requirement that was quietly dropped in 1995. Prior to this, the federal government's emergency management function had been restructured or moved between government portfolios over a dozen times over the course of about 40 years. A trend that's continued with several more rearrangements before disappearing as a distinct government agency when it was subsumed into Public Safety Canada by the Department of Public Safety and Emergency Preparedness Act. The Emergency Management Act that was passed in 2007 to replace the Emergency Preparedness Act again revised the approach to how responsibilities were distributed within government. It created a more balanced responsibility for emergency planning, sitting with every government minister, while the minister responsible for the act is tasked with setting the standard, providing coordination, and ensuring an appropriate level of preparedness. This approach determines how government agencies are, or at least should be, ready to meet the demands of all four types of emergencies. The Emergency Management Act requires all the ministers to have emergency plans for their portfolios that include any programs, arrangements, or other measures to assist provincial governments and through the provincial governments, local authorities, and any federal, provincial, regional plans. It is unclear to me if any such plans existed within the federal departments that may have included programs or arrangements to assist provincial governments with this kind of public order disruption, or if they were federal, provincial, regional plans for Ottawa or for other sites. I accept that such plans may have been in place but not publicly available. The organizational structure that we have remained in place from 2007 to 2021, something of a record for emergency management in Canada, when the Prime Minister separated the Emergency Management Act's ministerial function and placed it with the new Minister for Emergency Preparedness. The implications of that change have not been fully resolved. Public Safety Canada has developed policy documents that form a loose hierarchy under the mandate of the Emergency Management Act. Many of these policy tools were in response to the 2008 report of the Standing Committee on National Security and Defence. That Senate report was titled Emergency Preparedness in Canada: How the Fine Arts of Bafflegab and Procrastination Hobble the People Who Will Be Trying to Save You When Things Get Really Bad. The report was not positive. The Senate committee concluded they did not believe the Canadian government have been doing their job in preparing for kinds of major national emergencies that are bound to confront Canadians in the coming years. Time is too short to explore each of the policy documents in depth, and I must also again say that as a citizen, I can only see what Public Safety Canada puts forward on its websites. You've already heard of the Emergency Management Framework for Canada, the Federal Provincial Territorial Agreement on its principles. There's also the Emergency Management Strategy for Canada and its associated interim action plan that sets fairly aspirational goals for the portfolio over the upcoming decades. But there are many other policies that are where the polish is fading. The Federal Policy for Emergency Management 2012 simply paraphrases the obligations created by the Emergency Management Act into a policy statement. The National Emergency Response System, 2011, describes how the federal, provincial, territorial relationships and coordination systems should be in place while also placing the principles of emergency management into a federal policy. The Emergency Management Planning Guide from 2010 was intended to assist all federal government institutions to develop their all-hazard strategic emergency management plans, each of which should establish the federal government's objectives, approach, and structure for protecting Canadians and Canada from threats and hazards in that minister's area of responsibility, and sets out how the institution will assess a coordinated federal emergency response. Also in 2010, they brought out the Federal Emergency Response Plan. Again, the website says it was last updated in 2010. It's designed to harmonize federal emergency response efforts with those of the provinces and territories, non-government organizations, and the private sector. And it includes in it the Federal Emergency Response Management System, which provides a governance structure and the operational facilities for the Government of Canada to respond to emergencies. It establishes emergency response functions and assigns tasks to different departments. I'm not aware of how any of this planning has progressed in the past decade, or if any of those plans developed or implemented were done so in regard to the 2022 public order emergency. However, Deputy Minister Stewart, the Deputy Minister from Public Safety Canada, testified to you on Monday, November 14th, and he said, I quote, "In general, we did not treat the protests as an emergency management issue, and that the framework that we've designed and agreed with the provinces and territories to deploy does not typically apply to issues of public security or in defense of law enforcement. It deals with natural disasters and the like." This is an interesting distinction that does not seem to reflect the laws and policies I have just discussed. For example, the Emergency Management Act requires each minister to include measures to support the Canadian Armed Forces in case of war. This should raise the question of which national emergencies the Emergency Management Act and all of its downstream plans and policies were meant to address, if not all of them. Of course, each type of national emergency has associated policies and procedures that fall into many different portfolios. Yet every federal government department is required by the Emergency Management Act to identify the risks to their area, and the express policy of the government is to take an all hazards approach, which includes addressing vulnerabilities, both natural and human-induced hazards and disasters. And all hazard approach takes in human-induced disasters that concern emergency management, including intentional events that encompass part of the spectrum of human conflict and the disruption of critical infrastructure. Again, this makes me question the relationship between the Emergency Management Act and the Emergencies Act if not all hazards and all 4 types of emergencies are to be considered in planning. That flurry of policy writing around 2010 may have seemed out of date, but Public Safety Canada joined the National Emergency Management Team late in the game. Prior to 1988, Canada had no emergency management legislation, while all the provinces had passed their own laws starting back in the 1950s. So there is now a lack of consistency across Canada's legal landscape with regards to emergency management. The provinces and territories each have their own statutes that combine features of both the Emergencies Act and the Emergency Management Act, but do not necessarily contain all the same requirements, nor are the provinces consistent in where their emergency management function is located. I also wanted to point out that there is another, this is going to move ahead, challenge that we have, that the Public Safety Act of 2004 amended various federal acts after the September 11th attacks. It inserted emergency directive powers to ministers responsible for certain acts to allow for urgent action for the purpose of public safety. For example, the Aeronautics Act was amended to allow the minister to make interim orders to deal with significant risk, direct or indirect to aviation safety. The power for ministers to exercise these emergency directives, added to the federal toolbox 15 years after the Emergencies Act was passed, could resolve many potential situations without recourse to a national emergency. This highlights that the Emergencies Act does not reflect the intervening decades of policy and legislative change within the federal and provincial government. And so I'll just make one recommendation type comment now. In line with the tiered approach that we have, the sections of the Emergencies Act on public welfare emergency and/or the public order emergency could incorporate a reference to the use of such federal directive powers at the request of a province when it is a question of exceeding the province's jurisdiction. This could be done by incorporating a reference in the Emergencies Act to Section 7C of the Emergency Management Act, where declaring a provincial emergency to be of concern to the federal government could then trigger use of those federal directives. Thank you.
Thank you, Professor Lindsay. One of the things that came up in the roundtable yesterday was about the role of the private sector. And so, Mr. Corley, you had a chance yesterday to talk about the important role that you saw for private security and policing responses, at least. And I'm wondering if there's anything you'd like to add to the comments yesterday about the role that private security, you see private security playing in sort of interagency and interjurisdictional responses to emergencies.
Well, I suppose picking up on yesterday's conversation, it seems to me that in a contemporary context, the private sector and private sector security are an essential and core part of the community safety ecosystem. in terms of provision of services. If we think in terms of the spaces that we cover in the course of a day, whether we're in a mall, private businesses, the property of private businesses, often the first line of security support comes from the private sector. This is well established. The 2014 Council Canadian Academies report on 21st century policing spent a lot of time speaking about the ecosystem of providers, of which they're a central component. And there's lots written on that. In very practical terms, the private sector bring with them know-how, knowledge, and legislative tools that the public police typically don't have. In terms of legislation, of course, they often bring with them private property owner rights in terms of trespass and other things like that. Secondly, they're a lower cost provider. So I think the example yesterday, and I won't go through the math, but if we think of the non-central functions that the police perform, particularly in the Ottawa case, where we had over, at least based on other testimony yesterday, over 100 barricades around the external perimeter of the red zone in Ottawa. And you can imagine the number of police officers manning each of those. And if those were, at least in part, supported by private sector, it not only comes at a lower price point, but it also allows the fully trained, fully sworn, fully equipped police officers to be deployed to greater purpose. So the private sector can be a tremendous asset here. As we saw in the G20, in that case, of course, we have three types of events generally. Those types of events which allow for months and months of pre-planning. And in the case of the G20, the private sector was intimately involved at all levels of governance, joint leadership, and in terms of tactics and operations. But that was on the basis of months and months of planning. And as I understand it, an agreement between those private sector groups and the Toronto Police Association. So in the second type, which is more along the lines of what we experienced here in Ottawa, in the absence of having pre-established protocols, et cetera, in place that in this case, for these purposes, would involve the private sector, there may not often be time to establish those sort of protocols when one considers provincial police legislation, Police Services Act, where the adequacy standards often stipulate that what the sworn police will do and that others can do where there's agreement. So in the type of protests that we saw in Ottawa with limited time, if these aren't arranged and planned for in advance, they're unlikely to happen. And then of course, the third type of incident is those that are unanticipated and don't allow for planning. So they're more spontaneous, at least as it pertains to police and other security apparatus. So it's important. These are two potential barriers that need to be addressed and would form part of that overall approach that we've spoken extensively about over the last 2 days around national standards, prearranged agreements and such. And Judith Sayers addressed it nicely in her comments as well, in terms of the time it takes to get these things in place. And when time is short, these are often overlooked. And as we saw, I would propose in the cases here in the National Capital Region, not engaging the private sector and not having these arrangements in place in advance and tested and exercised. We saw tremendous pressure on finite police resources. And of course, in Canada, my final comment is the private sector security outnumbered police in Canada by a considerable factor.
Thank you. Mr. Teschner, do you have any thoughts from your experience on the appropriate role for the private sector in interjurisdictional responses to emergencies?
Sure, I'll start just by piggybacking off a bit of what Cal said on the private security piece, and then I want to talk about the private sector more broadly. Cal spoke about the G8, G20 in Toronto. There was also the Pan Am Games, which depended heavily on private security. I haven't done a jurisdictional scan to see whether or not the Ontario model, where you have within the Ministry of the Solicitor General a private security section that's responsible for essentially the regulation of private security in the province to ensure that applicants meet a certain standard in order to be given a license to operate as a private security person, and that there's additional standards in terms of training has been emulated or not. But certainly, I think that provides a little bit of confidence in the security apparatus. That said, if private security is going to be engaged, and if you have the benefit of either planning for a specific event or recognizing that you're going to need to depend on private security resources for future events writ large, you need a structure. You need a structure that allows it to seamlessly and in a coordinated way plug in to the other security and policing resources that are going to be deployed. You need to ensure training standards. You need to ensure lines of accountability and clarity with respect to roles, responsibilities, and command and control. These are things that can be, to Cal's point, be put in place in advance, can be tested, can be exercised, so that you know that it works when it needs to work. And so that's the piece that I'll say about private security. But outside of private security, you have the private sector. And I think when we talk about the way in which emergencies get responded to, there can be no doubt from the comments that are made today that a myriad of stakeholders, based on the geographic location and the nature of the emergency, are impacted in relation to that particular emergency. And so looking for mechanisms and ways to engage, maybe on a sector basis, these representatives, both in the planning and in the actual response to an emergency, I think is vital. These stakeholders of interest can help monitor and help crystallize the issues, can help in relation to planning, can help with respect to public communication and awareness, and can help in the recovery period that follows. These are groups like local business improvement areas, chambers of commerce, community hubs that are hubs for a variety of community organizations that serve the public, residents associations, municipal service providers. And from the Toronto convoy experience, it includes the healthcare sector and hospitals. Hospital Row was a priority in order to ensure that whatever was going to happen in the city over the course of that weekend was not going to impede the access of patients, physicians, nurses, hospital staff, or families from getting in and out of hospitals. And so I think that's a good example that illustrates the importance of looking at the sector-based response to emergencies, the sector-based impacts, and determining an appropriate structure to engage them. So again, they can be part of the planning process and can mobilize in accordance with those plans if and when the time comes.
Thank you. So as much as I'd like more discussion on the points that have been raised, I'm going to move us along to the Emergencies Act and to pick up on some comments made earlier around the importance of thresholds and procedures for escalation. And in particular, I want us to look at the question of when can the federal government declare an emergency arising from a failure of another level of government to exercise their ordinary jurisdiction? And Professor Newman, I'm hoping you can start us off with how to think about the answer to that question.
Sure. Well, it's certainly a thorny question, and it's actually important to think about how that question is asked. Because to suggest that the federal government can grade the passing grade or failure of another government when it acts in its ordinary jurisdiction or chooses not to act in an outwardly visible way could actually risk going beyond the powers of the federal government. Another government not acting in an outwardly visible way may actually be the policy choice of that government acting within its area of jurisdiction. And I mean, this could be very difficult to judge in some situations as to just what is happening, but we could think of a lot of different scenarios that might actually have different answers to this question. So certainly if the federal government were acting within an area of its own unambiguous jurisdiction, then but it was somehow affected by a province not acting, well, then it's unproblematic for the federal government to act because it's acting within its jurisdiction. The more challenging situations are, well, what if a provincial government seems unable to do something, or if it's unwilling to do something that matches with what the federal government is hoping, well, then where do we go? The situation of a provincial government rendered unable to act in some way is actually a thorny one in relation to the Emergencies Act. If a provincial government's cabinet were for some reason unable to meet and unable to communicate in a worst case scenario, in section 25(2), in the context of a public order emergency, there is a way in which the federal government can proceed even without consulting with that province in advance of it acting. In section 14(2), in relation to a public welfare emergency, there actually, or section 14, I should say, not just 14(2), in relation to a public welfare emergency, the consultation and consent requirements of a province in relation to the emergency just within that province actually would pose a problem for the federal government being able to act in that scenario under the Emergencies Act. So there may actually be situations that are really difficult to catch and to entrench perfectly within the Emergencies Act in a way that's responsive to the needs. And I guess I'd say there is always the possibility of the federal government passing emergency legislation outside the Emergencies Act based on the POEC emergency power. But crucial for that would be that the federal government be able to convene Parliament and that Parliament be able to function. One of the disturbing incidents in what occurred in Ottawa this year, to my mind, was that Parliament's ability to carry out its review of the use of the Emergencies Act was on a particular day actually blocked by what was going on in Ottawa. And it's essential that there be ways sought of ensuring that government can continue to meet as required, particularly if it were in a situation where it might need to pass additional legislation on an emergency basis. So that would be a situation depending on a lot of different things. If a provincial government were actually unable to act, well, that would justify the federal government acting conceivably, but it might actually be blocked by current provisions of the Emergencies Act in some situations. So complicated scenarios. The really challenging situation here, though, is if a provincial government took a clear policy view in an area of its own jurisdiction, in its ordinary jurisdiction, and there weren't a clear federal stake in that, it might be that the federal government doesn't have simply a chance to jump in on that. So the question, when can they and when can't they, it really depends a lot on the context. And of course, some contexts will mix together these different considerations. So I think it's really important to think about the range of scenarios as between a provincial inability to act and a deliberate policy choice by a province not to act in an outwardly visible way, and to think about the degree of impact on other members of the Federation as a factor that that could come into things. When I was thinking a bit about these types of issues in advance, I was thinking, well, the solution might be in improving the consultation provisions within the Emergencies Act further. And I still think there are improvements that could be made there in terms of defining additional types of scenarios and the types of consultation that should occur. But I also think it may actually be very challenging to capture all of those scenarios in a way that keeps clear legislation, that doesn't make things worse. And I do think it's very important to ensure that steps are taken to ensure the ability of the federal parliament to continue to meet in some way, even in the context of more challenging emergencies, and that actually is necessary given the possible need to pass additional emergency legislation in some situation that might not be captured by the existing act. The other thing I'll just throw in as one further wrinkle is that it's also important to think about the term emergency and the concept of emergency, both in terms of what's an emergency versus what's a set of simultaneous emergencies, and whether they're linked or not bears on how some of these provisions on consultation and consent by the provinces actually play out. And it's important to think about what an emergency means in temporal terms. So if someone's just thinking about the emergency that needs to be responded to this afternoon because there's a pressing emergency, something genuinely urgent, well, that's one scenario. What if a government has weeks or even months to think about the situation that's to be dealt with under emergencies legislation, or the cleanup efforts after a natural disaster extend well beyond the moment where there can't be any consultation or any discussion. This is something that that actually has been written on in the Indigenous context. A scholar named Courtney Kirk, who's published who's produced a thesis on emergency management in the context of First Nations, points to this issue where sometimes if you talk about creating all kinds of exceptions for emergencies, if one is thinking about the situation where there's no time to do anything other than just to react, well, that's one thing. But if you're talking about using emergencies legislation to carry out reconstruction afterwards, which is what has happened at the provincial level, for example, in the context of certain kinds of natural disasters, well, then it's actually much more feasible to carry out all kinds of consultation and discussions that might not be imagined in the context of something that needs to be done this afternoon. And so it's really important to break down these concepts a lot further. And I'd say to improve the, my recommendation would be to try to improve the consultation provisions of the Emergencies Act, but also to recognize that it may not be possible to capture everything about that, and to ensure that there's an ongoing ability of the federal government to function, even conceivably to pass additional legislation in response to emergencies in some situations. And that means Parliament may need to be able to meet in some innovative ways. And there was that unfortunate incident during this year's events where there were actually concerns about that. So I'll stop there and say that those would be a few comments in response to that question.
Thank you, Professor Newman. Professor Lindsay, do you have thoughts on this question?
I do. I certainly agree with the point about why that failure has occurred, whether there is a choice or whether there was some uncertainty, or if it's simply the inability of a provincial or local jurisdiction to exercise a power. But I think another issue should come up is when that failure occurs. Research shows that impacts of natural hazards like flooding may result from a failure of jurisdictions to act decades earlier, for example, in exercising local land use planning tools. So it's unclear to me if a declaration under the Emergencies Act to impose federal powers when a province or a local authority has chosen not to exercise a power that's within its jurisdiction would violate the aim of preventing a conflict between provincial and federal orders. I also want to mention that the consultation required by the Emergencies Act is not the only time, nor the appropriate time, to have discussions about what to do, who should be doing it, or many of the other points raised. All of the planning and strategic tools that I mentioned earlier and that have been in place for over 15 years should have addressed most of that consultation. There's also a challenge across the country in the provincial legislation that the provincial legislation is not consistent in the powers that it gives the lieutenant governors in council or mayors, but also between the legislation. So let me give one quick example from Ontario. The Ontario's Forest Fires Prevention Act says that for the purposes of controlling and extinguishing a fire, an officer may use any privately owned equipment and may employ or summon the assistance of every able-bodied person over the age of 18, except persons providing essential services and persons physically unfit, and on private lands may take such action as he or she considers advisable to control and extinguish the fire. Whereas Ontario's Emergency Management and Civil Protection Act says the Governor and Council can make orders in respect of authorizing, but not requiring any person or class of persons to render a service of a type that person can reasonably deliver. And I know from my own research in Manitoba, we probably have 7 or 8 acts that grant very similar powers to different civil servants in different circumstances other than the Emergency Measures Act. Like the ministerial directives, I feel that we should be doing a much better job of first coordinating and informing the public of the kinds of powers that the government may exercise in these sorts of emergency situations. Also, the powers available to the federal government under the public welfare emergency in particular overlap with the powers of the provinces, mostly because the provinces all took their powers from the Defence of Canada regulations in 1939, played with them for 50 years, amending and adapting them, and then in 1988, when the federal government wrote the Emergencies Act, perhaps naturally they gave themselves the same powers that the provinces had been giving themselves for the previous decades. So we need to be taking, I think, a threshold approach to defining disasters. We need to be able to make sure we can have a clear escalation from routine local emergencies to a local state of emergency at a municipal level to provincial declarations, and the provincial emergency measures legislation takes this into account. So therefore, that question of exceeds the capacity that we look for in the Act should indicate one of 2 situations. The province and its local governments do not have sufficient resources to carry out its own emergency orders, or as was suggested just a moment ago, the impact has rendered that province incapable of mounting an organized response under its own legislation, and therefore requires the Government of Canada to exercise those same powers as a replacement. That latter scenario is very unlikely, but it's a reasonable approach to the risk of catastrophic failure of a provincial and local emergency. That is what the United States went through with Hurricane Katrina. New Orleans and the state of Louisiana, their emergency management system collapsed as well. And so in the US, they've recognized that there could be times for catastrophic failures where the systems we put in place to deal with disasters fail as well. We don't have that in Canada. The other issue that I should just point out as well, if I may, contrasting us with the United States, is that in Canada, all of our resources can move between federal, provincial, and local governments without a declaration. We don't have to declare a state of emergency for federal government departments to help a provincial department or for a provincial department to help at a municipality. That is why in the States, where they have to have the declarations, they declared in 2019, they declared 61 major disasters because they have to declare them in order to have the money flow. We don't have to have that. And so again, our plans are more important because we can be doing a lot of this work without having to declare a state of emergency. So I guess it comes down to a somewhat philosophical element in Canada's entire emergency management system, that it presupposes that emergencies cannot be avoided, and therefore our governments rely on these laws of last resort as their normal practice. This reinforces that misconception that our emergency management system is only working when it is responding. And this is, again, contrasted by other nations, and I heard New Zealand mentioned this morning, that see avoiding the need for extraordinary actions as the purpose of comprehensive emergency management. Thank you.
Thanks for that, Professor Lindsay. This is an important question, and one where from the answers already, I can see there's a lot of complexity. So I'm just wondering, we've got a little bit of time on this if others want to contribute. Yeah, Mr. Teschner? Is that...
Sure, I'll add a few thoughts. First, to agree with my colleagues, and in particular, I want to pick up on Professor Lindsay's point that we live in a federation and we have to respect spheres of jurisdiction and the constitutional divide, but some harmonization across the provinces to back up Professor Lindsay's point when it comes to the approach taken to provincial declarations of emergency, and the provincial approaches, I think, would serve us well. And essentially, the lens that should be applied is they should plug in well to the federal sphere to the extent that that's necessary. I think they need to be designed for purpose that way. I'll also say that in addition to local governments not having the capacity, or the second option being rendered incapable by virtue of the emergency at hand, I would add a third piece for consideration, and that is where the federal government's stake or interest is engaged because there are emergencies happening across the country and some form of coordination that can only be brought to bear by the federal government is required. I think unpacking that a little bit more in light of what we've seen more recently in terms of events would potentially be helpful. Of course, in addition to the provinces and the territories, to President Sayer's point, we have to also think about First Nations in that context as well. And so those are some of the points I would make there. The other thing that I will say, though, is presumably when a province or a territory or a First Nation is consulted in the context of a discussion with the federal government on emergencies, they should be informed by what is happening locally on the ground at a municipal level. I think making sure that provinces and territories understand that and putting some meat on those bones would perhaps be helpful. But related to that, municipalities are not always going to necessarily know what the threat picture looks like. And so promoting information sharing, threat risk assessments that might be conducted by provinces, might be conducted by the federal government, and ensuring that municipalities impacted or likely impacted have access to that information so that they can properly and in an informed way make a determination about what their capacity actually is or isn't, I think is vital.
Thank you. Other thoughts on this question? So I wonder if we can just keep going with that with that response, Mr. Teschner, around sort of questions about optimal mechanisms for consultation when declaring a national emergency. And so what might that consultation look like, recognizing the points that have already been made, that it's maybe not just about the consultation happening at that exact moment, that we need to take a broader temporal view of that. So what should those mechanisms for consultation look like when declaring a national emergency? And how should disagreement between levels of governments on the use of federal powers, emergency response powers, how should that kind of disagreement be reflected in federal decision making? And so, Professor Newman, can we go back to you on that question? You brought this up earlier.
Sure, and I'll just preface it saying I agree entirely with the notion that there ought to be discussions well in advance of any particular emergency arising, and that the opportunities for coordination between governments start well in advance of the need for emergencies legislation, and years in advance, as has been suggested. But in the context of an emergency type situation arising where there's contemplated use of the Emergencies Act. Currently, there are a number of provisions in the Emergencies Act on consultation. One could mention Section 14, Section 25, Section 35, and Section 44. And of course, as has been highlighted a couple of times now, the Emergencies Act was drafted in a period prior to the federal government properly recognizing Indigenous rights, not just of First Nations, but of Métis rights holders and the Inuit as well. And I guess I would just say, here that there needs to be an updating of the Act around Indigenous consultation at minimum, simply to meet existing constitutional obligations on the duty to consult, for example, but also in relation to the further reaching dimensions that consultation needs to have in that context in light of Indigenous jurisdiction, as has been highlighted by President Sayers. But this legislation is years and years behind the development of law in the fact that there hasn't been any kind of updating in relation to Indigenous governments. In terms of consultation with provincial governments, I would say there could be things actually learned from the duty to consult jurisprudence in the context of Indigenous governments, interestingly enough, because the word consultation appears in the Emergencies Act, but with relatively limited sense on what that might mean in the Act. Thinking about what makes for meaningful consultation, which is the standard in the context of the duty to consult Indigenous peoples, thinking about that sense of meaningful consultation, if consultation in the Emergencies Act is there to ensure in part that the federal government doesn't act in a way that's problematic vis-a-vis the provinces. I think that's one of its central roles within the Act as it exists. Then the idea that the consultation ought to be meaningful, ought to be providing an exchange of information and response, ought to be recorded in a meaningful way to show how the federal government considered acting differently in light of the information or perspectives received from provincial governments. That would be a preferable means or a preferable form of consultation. And it may be possible to add language to the Act to reflect that, or it may be possible to engage in more meaningful consultation even without amendment of the language of the Act, but based on different practices. And I think that's an area where there could be some learning even from this context that the Act itself has unjustly and illegally excluded over the past number of years and decades. So I guess I'll say that much. Another issue, of course, that arises is in relation to the role of municipalities. And this is complex in terms of whether the federal government ought to be consulting municipalities, has some real delicacies to it, because municipalities, of course, in constitutional terms, are creatures of the provinces, and it's within the constitutional jurisdiction of provinces to create municipalities and to shape municipalities. And were the federal government simply to be acting in a way that ignored that principle, there would be some problems in terms of jumping past levels of government. At the same time, the federal government certainly wants to be informed by what's occurring in municipalities at a local level where that knowledge is held, and it might be appropriate to include language in the Act that at least permits the federal government to consult municipalities. That obviously has already occurred in the context of the recent use of the Emergencies Act in 2022. The consultation record reflects that the federal government actually was in contact with the mayors of some municipalities. Language that would specifically authorize that in the Act might be appropriate. Language that would actually encourage that might well be appropriate, subject to that delicacy in relation to the federal-provincial interaction here and the province's fundamental constitutional role in relation to municipalities. But in terms of getting information from larger municipalities or directly affected municipalities, it certainly would be helpful to the federal government to have that. And so I think there's room to recommend a number of possible changes in the consultation provisions or practices, simply to say it's essential that there be incorporation within the Act of appropriate consultation provisions in relation to Indigenous rights-bearing communities, or a constitutional standard is not being met there. This goes further in relation to the UN Declaration on the Rights of Indigenous Peoples Act in terms of what provisions should be there in terms of consultation with Indigenous nations and Indigenous peoples. It would be appropriate to consider at least practices or possibly statutory language related to making consultation with the provinces more meaningful, or ensuring that it's meaningful. And it could be appropriate to offer some specific authorization or even encouragement in relation to engagement of the federal government with municipalities in some situations, subject to some complex delicacies on that vis-a-vis the provinces. Those would be some initial thoughts in terms of some possible changes in relation to consultation.
Thank you, Professor Newman. President Sayers, do you want to come in on this point about consultation and optimal mechanisms for consultation when declaring a national emergency?
Yes, for sure. Am I on? Oh, yes. So, you know, the consultation pre-UNDRIP, you know, is a bit different than what it is under UNDRIP. Because, you know, in some cases, you need consultation and collaboration leading to the free, prior, and informed consent of Indigenous peoples. And there are certain specific areas within UNDRIP which that is required, such as the legislation. So if the Emergency Act is being amended, it should be with the, you know, leading to the consent of Indigenous people. In British Columbia, the Emergency Act is now being amended and should be, and is working with First Nations. I know the question is often asked is, how do we consult with 633 plus First Nations across Canada? That's a good question. But oftentimes, if you work with Indigenous people, some may want to do it on their own, some may want to do it regionally or provincially. But I think what's really important here to remember is that the rights holders are the ones that have the say, and that the federal organizations can be talked to, but in the end, it should be the rights holders that make final decisions about what that should be. There needs to sit down and work out a process with First Nations on how consultation should take place under the Emergency Act. Another tool the federal government has, of course, is in their Universal Declaration on the Rights of Indigenous Peoples Act. They have to put together an action plan. So over 5 years, they can define what needs to be done in that action plan and then go about and do it. And right now they're collecting from First Nations what it is that we need to do. So it really is important to sit down now and to start talking about what's happening. But if an emergency is happening on specific First Nations lands, they should be the ones that are talked to. If it's 1 or 10 or whatever, they should be talked to first. If it's a national emergency, of course, everybody has to be included. And so just remembering that the duty to consult goes beyond consultation, and just working out these protocols with First Nations is, I think, one of the best kinds of things that you can do. And in particular, what is important that I haven't mentioned yet is that First Nations know their lands, their resources, and they have the best knowledge of the land. So if we're talking about fires, if we're talking about flooding, they're the ones that know their lands the best. And that sort of knowledge is invaluable in some of these emergencies that we talk to. And that also could be part of those protocols that could be used. So I think the opportunity, you know, in this new era of UNDRIP and reconciliation is it's time just to dialogue, you know, and take advantage of First Nations willingness as well to sit down and do this and not to be excluded, because I think those kind of days are over and it's time to open up and to figure out how we can work together in all kinds of emergencies. Thank you.
Thank you, President Sayers. So I wonder if others want to come in on this question of consultation, and particularly thinking about where we started, thinking about maybe the superstructure that's there and sort of having mechanisms in place for escalation. And so when we're at that stage in which escalation is going to happen, what kind of consultation needs to be taking place? But Professor Lindsay, please.
If I can, and this is very much speaking from my practitioner hat and not my professor's hat. The provincial emergency management systems are designed to coordinate the priorities during an emergency response. It may be that the desires of a large city do not match the needs of the wider province, or that the needs of the one community don't match the needs of a neighboring community or First Nation. But I feel that that consultation piece, maybe if we replace the word consultation with the word coordination or discussion, because all of the who does what when piece should have been decided beforehand. And the Emergency Management Act obligates the minister responsible to have those consultation processes in place beforehand. I feel that what we should be looking at is making sure that when the federal government does consult with the Lieutenant Governor and Council, that that provincial perspective has brought together all of the local perspectives. I don't want to wander any further into the question of the Indigenous consultation, but we should have that clear process within the response system to make sure that affected municipalities are integrated into the provincial perspective that's going to the federal government. That is the emergency incident management system that we have in place. Different municipalities will be trying to achieve different things, and they don't always have all of the same goals. So I would add that. Though, as an alternative in terms of the local government, right now, the federal government has the ability, it's under the Emergency Management Act, to recognize a provincial declaration of emergency as being a declaration of concern to the federal government. This really came out of the ice storm, where the ice storm wasn't shutting down the federal government across the country, it was just shutting the government down here in Ottawa and in parts of Southern Ontario and Quebec. So the federal government wanted to know, when would a province likely be struck by a disaster that's going to have an impact on our ability to do our job, not our jurisdictional issue, but just our business continuity issue. And the Emergency Management Act covers all of that. The question about that was raised earlier about how the parliamentarians get in during the convoy, the Emergency Management Act requires all of the provincial departments to have business continuity plans. So the fact that things didn't go well doesn't necessarily mean that the framework wasn't there, just that it hadn't been operationalized fully. So I think there's alternatives. As I said, because the federal government can identify a provincial declaration of being concerned, perhaps in the pre-planning stage, in consultation and discussion with the municipalities and the provinces, certain larger cities, I'm thinking of a city like Vancouver with the port, or Halifax with its port, could be identified, likely in regulation so that it can be changed, that says that a declaration of an emergency, say in Vancouver or downtown Toronto, would also be a declaration of concern to the federal government without necessarily bypassing the fact that the municipalities are under the provinces. It's just saying that if a big event happens in a big city, the federal government wants to be ahead of the game, not waiting to hear about it from the province. That doesn't have to mean that the federal government talks to every single municipality, but that there's a system for the federal government to talk to the province and for the province to have coordinated that wider ask. So, thank you.
Yeah, good points. Others on this? Yeah, Mr. Corley, I see you online. Go ahead.
Yeah, and perhaps I'm coming at this from a bit different angle, and we seem to be talking, which is important, talking about consultations prior to invoking the Emergencies Act, any of the parts of it. As it pertains to part 2 specifically, I'd like to encourage us to think about this more upstream from that. In essence, if at the FPT, Indigenous municipal levels, there's intentional proactive measures that support the development of a highly functional and effective national framework that addresses public order protests and emergencies, that is properly executed and properly implemented. It should, in most cases and circumstances, establish conditions that negate the need for governments to even consider invoking the Federal Emergency Act Part 2 as it is today. The same we see in major case management. Major case management applied with the kind of rigor that we see in Ontario and several other provinces has had a huge impact on the quality of the investigations that are brought forward for prosecution, et cetera. And one needs only to reach out to different Crown prosecutors that are operating in those areas and talking about pre and post implementation of major case management and how it's matured. It's a significant difference. So I think that proactivity and all of the issues we talked about earlier in terms of national framework could go a long way to preventing or even needing in many circumstances to even consider this. Thank you.
Thank you. So we have about 10 minutes before the break, and I think in your responses, you've covered the things that we've discussed in preparing for this, and so I think I'll just open it up to all of you experts to see if there are points that you haven't raised yet that you would like to raise, if there are things you'd like to elaborate on or clarify, maybe more specifics around changes that you might like to see to the Emergencies Act flowing from this conversation that we've had so far.
Yes.
President Sayers.
Yes, I just wanted to, I don't know that timelines and legislation is the best thing, but the urgency of emergencies, especially in health, the pandemic's not over and we know that there'll be more coming. The changing in the weather due to climate change, the flooding, the tsunamis, there's just so much happening in this world. And I think that we need to act sooner than later in putting in place protocols and working together, the roles, responsibilities. Let's be clear that so we're not fooling around at some time and trying to decide if it's a provincial jurisdiction or federal jurisdiction or First Nation jurisdiction. We just need to, I would just like to see us be really clear and doing things very quickly so that we can address things that are going to affect our people, our rights, our lands. I just wanted to add that to the conversation. Thank you.
Thank you. Okay, possibility of timelines to keep things moving along. Other thoughts? Mr. Corley?
Thank you. Just picking up again on the conversation or the inputs that Ryan and I had with respect to the private sector, private security principally, and Ontario's new Comprehensive Police Services Act, yet to come into force, lays out in very nice fashion how, when the private sector security are engaged, they fall under the umbrella of the Police Services Board, and that the requirements in terms of adequacy standards and that is well established. I don't know, Ryan, if you want to pick up on that, because I think there's an important element of local governance here that really applies.
Sure, it's Ryan Teschner jumping in. I'm a big proponent of all things governance, Mr. Commissioner, if you couldn't tell from the last session and from this one. And so I think where we're going to mobilize local resources, we need to ensure that there's a framework in place so that everybody knows their responsibilities, their obligations, and who's in charge, and who picks up the tab, and other issues that are related. And so I think certainly what is in the Ontario legislation is an important step. And I think it comes back to something that I said earlier. Where policing is being mobilized to respond to a particular emergency, the policing response when it's in a municipality comes under the legal statutory responsibility of a local police services board or commission. And that legal reality cannot be a fiction. And so whether we're talking about how private security comes into the fold and how that needs to be part of the governance web that a police board provides locally, or whether we're talking about consultation, as we just did in the previous conversation, where those impacts need to be assessed at a local policing level, boards and commissions need to be part of this fabric as well. So I think that's a point not to be lost.
Thank you. Professor Lindsay?
Oh, I was just going to pick up on that opening analogy that you presented me with the idea of the Emergencies Act being a tool. And there is that saying that if all you have is a hammer, every problem looks like a nail. That's what we've had in our system. We have a legislation that has very strong powers to use in response, very few obligations to reduce risk or to prepare our communities or to have proper recovery. And with all due respect to all of my emergency management colleagues, we have filled our emergency management system, to use the hammer, with welders and stonemasons, but no carpenters. The Emergency Management Act is what lays out the tasks. The Emergencies Act is one tool, but what's really lacking in Canada is a strong professional emergency management cohort, a strong profession, where the emergency managers are trained in emergency management and are practicing that all the time throughout their careers. And again, I started my career in emergency management at 25 as an emergency manager. I never worked in a fire department or I've never a police officer. I've been an emergency manager the whole time. And that, I feel, is making a big difference. And that's what other countries are moving towards as well, really pushing higher education for emergency managers and seeing it as a separate profession, which is something that we need to do more of in Canada. So, thank you for that.
Thank you. Commissioner, we have about 6 minutes before the planned break. Do you have questions that you'd like to pose now? Or would you like us to break early?
Well, maybe I'd like to just a little bit more follow-up to and some of the comments made by Professor Newman about federal jurisdiction. Towards the beginning, he spoke about the issue of whether it was an emergency would be within federal jurisdiction or not. And he made a couple of comments that I'm not sure if they were intended to deal with this situation or not, but he spoke that if it related to borders or the national capital region, it may be federal and not be related to or in provincial jurisdictions. And the evidence in this case is certainly that the borders were an issue, not technically the blockade at the border, but rather the blockade that in effect blocked the border. And similarly, the national capital region, the occupation as it's referred to in some cases, was in the national capital region. And I'd just like him to, if he can, to elaborate on what he was referring to and whether it's in fact related to the, or could be tied to the events such that it was within federal jurisdiction or not.
Okay, thank you for the question. I'll say I wasn't trying to refer specifically to the present situation because I understood the purpose of these roundtables as to reflect on matters in a more forward-looking way. But simply to say that parts of the Emergencies Act are grounded in federal jurisdiction without the use of the POG emergency power, without the emergency branch of the peace, order, and good government power. I mean, one could give other examples simply in relation to an international emergency or a war emergency being largely within federal jurisdiction to start with, although with pieces in provincial jurisdiction. That said, I mean, the response in relation to something with provincial elements could have elements where there would be a natural federal jurisdiction, but there would also be room for the federal government to deal with that legislatively in some way outside the Emergencies Act. And so I guess, obviously, in referencing the National Capital Region, I was affected by seeing the vulnerability of Canada's national capital this year, as I think probably many Canadians were, in seeing that Canada's national capital is humiliatingly vulnerable to all kinds of problems in some ways. And I guess the response doesn't necessarily need to be the use of the Emergencies Act in future. The response could readily be subject to all of the discussions that would need to take place on this and the disadvantages that there could be, but it could be in the form of federal legislation taking further steps in regulating the National Capital Region and assuming a larger federal role in the National Capital Region, as occurs in some other capital regions of other countries elsewhere in the world. So it's just a generic point about jurisdiction in some ways, to say there can be bases for federal jurisdiction that don't rely upon the POG power in relation to some kinds of emergencies. And that also says that in relation to some kinds of vulnerabilities, there may be good legislative responses that are outside a future use of the Emergencies Act or outside an amendment of the Emergencies Act to try to cope with something that the federal government hasn't dealt with through other kinds of legislation that it could use to deal with those same types of issues. So I hope that makes it clear. I wasn't trying to comment on this particular situation, although obviously at a general level, as all Canadians, I saw some things about this situation, but obviously your commission has engaged in extensive hearing of evidence and extensive it will engage in extensive fact finding in relation to this situation. So I speak only in relation to the most generic of understandings that the National Capital Region was a place whose vulnerability was revealed a bit by the situation this year.
Thank you. I think we're now at the time for the break, so we're going to take a break until 4:30 and see what questions have come in and how we're going to trouble you with further questions and seek further thoughts when we come back at 4:30. So a half-hour break.
The commission is in a recess for 30 minutes. La commission est levée pour 30 minutes. Ça va, commissaire? Oui, je pense que oui.
Je sais pas où est l'autre.
Al, Dwight, Judith. I think we're good. Madame Sayers est... Ben, je la vois pas active, mais elle est là. Oui. Okay. The commission is reconvened. La commission reprend.
Okay, so we have a few questions for the experts that we'll try to get through in the next 30 minutes. All right, so Mr. Teschner, I'm going to put you on the spot for the first question. So there's some interest in the UK model of emergency preparedness committees that you had brought up earlier, sort of this idea of having kind of the need for multi-jurisdictional committees in order to sort of for jurisdictions to set themselves up for a coordinated emergency response. And I guess we're interested in learning a little bit more about that, and in particular, whether and how that model accounts for challenges of personalities that a couple of you have referred to, and politics, and sort of, is there something built into that, that if you've got the parties at the table and they come to an agreement about how to coordinate a response, that it's more than just a discussion, that they are sort of walk away and then they implement that agreement. So I don't know if you could elaborate on that UK model with that in mind.
Yeah, I mean, as I understand that model, it brings together all of the relevant players around one table. It still operates with respect for each of those partners' areas of jurisdiction, but it facilitates. We talked earlier about consensus and we talked about consultation. You can view this as an ongoing consultative body where both in advance of and during an emergency and thereafter through the recovery phase, you ensure that you're tapping into the expertise, the perspectives of all of the players, ultimately trying to build consensus, certainly ensuring full visibility with respect to one another's actions and operations and perspectives. And as I mentioned earlier, also providing some visibility with respect to threat assessments so that where all orders are engaged, federal, provincial, territorial, Indigenous rights holders, and through the provinces, municipalities, everybody is starting to appreciate what the national picture looks like and what role they play with respect to that national picture. And so that's what I understand these bodies to help facilitate. Now, the role that, let's say, the federal government could take around that body may differ depending on both the nature of the emergency, the scope and magnitude and its reach. Sometimes it might be more of a monitoring role. Sometimes it might be more of a leadership role. And I think that goes back to what we were talking about earlier. What are the escalation points? How do we better articulate when that federal government interest is actually engaged such that it has more than a monitoring role and actually can play the role of coordinator or even sometimes decision maker?
Thank you. I don't know if others have thoughts on that question. Yeah.
If I may,
Professor
Jack,
Lindsay.
Thank you. I just wanted to point out, though, that emergencies happen in the context of the country. Countries like the UK and New Zealand that are unitary governments that don't have provinces that also have their own legislation have different systems than us. And so there's emergency management principles that can be transferred, but we have to tailor them to our situation and not just see one solution. This morning, there was a mention of New Zealand having a minister of police. The police is a national service. So of course they have a national minister, and so we have to respect that difference too.
Mm-hmm. I think that's a good point. Though the more jurisdictions that are involved, that would sort of speak to the need of
more coordination.
Yeah, more coordination, right? Making that type of multi-jurisdictional consensus building even more important. Thank you. I think actually there's another question that's related to this, and I think we'll bring a few more of you into the conversation. So one of the points that came up earlier was around the importance of sharing information across jurisdictions, and I wonder if some of the experts here might be able to elaborate on the challenges that might be involved in sharing information, particularly when there are sensitivities involved in the type of information that could be shared, whether it's national security, maybe it's it could even be inventory type things, or it could be personal health information, like the example that President Sayers brought up earlier. So I think we'd just like to hear a little bit more about some of the challenges and barriers to information sharing that would be encountered in bringing about this kind of structure where you've got everybody at the table.
Were you looking for anybody?
Anybody, so I'm looking for nonverbal cues here. Who might like to weigh in?
Here's one.
Thank you, Mr. Teschner.
I'll say that while I respect that exchange of information can often raise concerns about legislative impediments, privacy impediments, and the like, I think we sometimes get bogged down in that more than we perhaps need to. There are constructs and mechanisms that allow for sharing of information if the willingness is there, and then you put the infrastructure in place. INSET, the example I talked about earlier, is one such example. The way in which police chiefs share information with police boards is another example. The provincial and federal security advisor regime is both an example and an opportunity. I don't know, again, I haven't canvassed every province and territory across the country, but certainly Ontario has a provincial security advisor. We know the federal government has a national security advisor. That might be a mechanism through which a lot of this information can be shared easily with that infrastructure already embedded and put in place. And so I think we have to look for vehicles and avenues to do it, as opposed to reasons not to do it.
President Sayers.
Yeah, I would think that, in the case of the COVID sharing information, the province pleaded the Freedom of Information Act. And, we kept on asking, well, at what point does a national emergency or the collective rights of individuals, the collective people have rights over the individual person? I just didn't see how saying that there were 10 COVID cases that we would actually say the 10 individuals. We wouldn't even know who they were. So I think sometimes there is far too much caution put into that. And maybe that needs to be defined in the Emergency Act when, critical information needs to get to various jurisdictions, that can be done as opposed to not being done. And I just feel that not only in health, but in some of the related issues that we've been having in flooding, incidents in the ocean, like there are some things that just need to be known. I guess I'm not sure how we define that, but it's something that, became a real, and I think that's why it took us 7 months to negotiate that, was trying to get around those privacy. And we actually brought a complaint to the privacy commissioner, and he just said he didn't have any tools in the freedom of information. So we need tools to be able to access the kind of information that we need during emergencies.
Yeah, thank you for that. And Professor Newman, I'll turn to you, but if you have any thoughts on where President Sayers just left off, that would be helpful, right? I do think that when these challenges come up, there are often legislative barriers that public officials can point to. And so are there legislative changes or specific legislative changes that need to be made to allow for sharing of information in these in emergency contexts? But please go ahead.
And I was going to build directly upon the comments just offered. I mean, the first comments, I think, suggested there may be times where some government officials are too risk averse in relation to decisions on that kind of legislation. But the easy solution in one way is actually to put in amendments to the legislation. Those don't need to be in the emergencies legislation. They could be in the privacy legislation itself. I'm not an expert on that area. I can't speak to specific amendments to specific acts, but I just wanted to highlight that it may be very appropriate for different pieces of privacy legislation to have better developed emergency exceptions.
Thank you. Mr. Corley.
Yes, thank you. There's other examples within the community safety realm that issues of information sharing have the barriers to information sharing have come up. And one that comes to mind is the risk-driven community safety and wellbeing interventions in Ontario. They'd be known as situation tables that pull together, 15 or 16 different agencies from across the public health, criminal justice, and social and human services sectors to look at individuals at acute and elevated risk. When these first got off the ground in Saskatchewan in about 2010, it was fraught with issues of concerns around information sharing and privacy. But what we found was working with the provinces and with the federal privacy commissioner, largely these were largely overcomable and appropriate processes put in place in terms of the handling and the and the control over such exchanges. And I'd also just comment on the Security of Canada Information Sharing Act. It too evolved out of concerns with the sharing of information even within the federal realm. So I think a starting point moving forward is to recognize that there are potential inhibitors, but like-minded and thoughtful people fully respecting privacy legislation, the rights of individuals, can find appropriate solutions to break through some of this. Thank you.
Thank you. Other thoughts? Yeah, Professor Lindsay.
And it has been addressed in the opposite direction. The federal government is able to collect proprietary information from, say, private critical infrastructure providers, and that information is specifically not available under freedom of information. The government needs to know aspects of private business, of telecoms and others, but they also appreciate that once they know it, it shouldn't go any further than them. So there have already been examples of how we've dealt with privacy in both directions that way.
Thanks. Okay, continuing on with this theme of sort of sharing, coordination, and then specifically about consultation. We had a good conversation earlier about meaningful consultation. And so I guess on that note, should the notion of meaningful consultation, if the Emergencies Act is reformed, should that notion of meaningful consultation be specifically about the question of whether to invoke the Emergencies Act, or does meaningful consultation mean consultation about the underlying circumstances, the issues, and the possible solutions? So just looking for a little bit more discussion on this idea of meaningful consultation specifically in this context of invoking the Emergencies Act. So is there anyone that would like to start with this?
No?
Yeah, President Sayers.
Yeah, I think that if there is enough time before an emergency, when things are building up and it looks like you might have to invoke the Emergency Act, then yeah, there should be consultations, beyond meaningful. We've had bad luck with the federal government on what meaningful consultation means. But if there's no time, like, if it's a war, war is different. But if there's something that hit automatically, then I think that we do need that timeline to talk to people afterwards, whether it's the 7 days or 3 days or whatever is reasonable. Because I just think sometimes that you just won't be able to do the consultation, but I think that should be limited.
Thank you. Professor Newman?
I'd just say that I hope I didn't define this too narrowly in my remarks on meaningful consultation before. Certainly thinking about the present statutory provisions about whether to invoke the Emergencies Act, yes, there should be meaningful consultation there, but to the extent that consultation can help in determining other possible solutions, that would be a very appropriate part to a better form of consultation. And a more enriched consultation, which I acknowledge the point that this hasn't happened consistently with the federal government and Indigenous communities, but the case law is there to say there's meant to be meaningful consultation. Well, concepts of consultation guided by that could lead to a richer range of options than just a binary invoke, not invoke choice.
Yeah, thank you. Mr. Corley.
To your question in terms of whether meaningful consultation should involve a very limited and narrow interpretation or more fulsome, I'd reflect back on discussions yesterday afternoon as well as today, and I'd suggest that implementing a national framework, such as a few of us have suggested, would establish the foundation for trust and understanding across various levels as pertaining to the subject matter, and a common understanding of goals and objectives, etc. In other words, setting a foundation for meaningful consultation when events come, such as have been described by Judith, which may be much constrained time frames that allow themselves or to allow for appropriate consultation. It strikes me that key stakeholder groups will expect and should be consulted with, even in the shortest of time frames, but that by instituting and implementing a framework such as been described, and I think the particular 5-point model that Brian suggested is quite appropriate as a starting point, would really lay the foundation for trustful relationships as pertaining to emergencies and public order protests. So when we get to the time where there is a very short order, that sets a foundation for even in a very short order of time that's available for consultation to be more meaningful.
Thank you. I mean, maybe I'll put this question in a slightly different frame. Is it if a government is not direct about the question that about invoking the Emergencies Act, does that mean that it's not meaningful consultation, even if the conversations that have happened have explored the range of underlying causes and a range of solutions? So I think that's because, I mean, one of the things that we've canvassed in this conversation is the importance of bringing a number of different governments and stakeholders to the table, but also that might create a challenge in terms of how forthcoming, I guess, and the kinds of information that can be shared in those conversations. And so, yes, we want to have a lot of smart minds at the table so that you're exploring solutions, but I guess if there's going to be a decision made around invoking the Emergencies Act, does that need to be directly part of the conversation in order for that to be a meaningful conversation and meaningful consultation? Yeah, Mr. Teschner.
I would tip on the side of, yes, the ultimate issue or the ultimate decision needs to be put forward. Obviously, you know, the government doesn't have to reveal necessarily to the table all of the considerations it's going to take back in formulating its ultimate decision. But there needs to be some transparency as to what is being considered. And in part, that's because the underlying facts and context, exploring that is obviously important in order to identify whether there are alternatives or other options. But importantly, if the government doesn't put on the table what invoking means, what are the specific regulations that they may put in place as a result of invoking the act? What are the impacts of those regulations on some of the actors who are going to be impacted? I don't know how you can have meaningful consultation in the absence of exploring those dimensions. And so from the ultimate question of whether or not to invoke, there flow impact questions that have to be part of, I would say, not consultation at a point in time, but ongoing consultation, because there's also a decision to be made about whether to continue having the declaration in place. And so there needs to be a constant feedback loop, if you will.
Thank you. Okay, so I have two questions here about other agencies, one that has been part of the conversation so far, and then a new one. So we've talked a bit about private security, and Mr. Corley in particular, you gave the example of how private security could have been used with respect to the events in Ottawa, for example, to man checkpoints, right, to man on the roads. And so I guess the question is, should police have the power to hire private security for specific functions during emergencies? And if so, do we need legislation to enable that? And what kinds of duties would you see private security appropriately assuming during an emergency?
Great questions. First and foremost, and I'd have to, take a look at the legislation across jurisdictions across Canada, but just using Ontario's legislation, it already allows for that. The challenge, as we heard earlier, has to do with timescales. So in the face of the Pan Am Games, as Ryan mentioned, or the G20, G8, where there was months of planning enabled, the private sector security were engaged because it allowed time to develop and implement those agreements under the appropriate legislation. And as I understand it, together with an agreement with the Toronto Police Association, for example. So the legislation, at least in Ontario, is there. The inhibitors, in my mind, come into play on the two different, the short order types, the spontaneous issue that arises, or those with very short time scales that allow for appropriate planning. And it's just a matter of the time it takes to get these in place, ergo, and back to our suggestion in terms of national framework protocols and arrangements that are there in advance, so these can be mobilized. In terms of the types of duties that private sector security agents could provide, I'd suggest that they fall in a couple of different buckets, but typically they'd all be lower risk to harm endeavors or duties than the public police are prepared, trained, etc., to undertake. So manning of barricades, other back office, middle office roles that support frontline policing. I mean, today the private sector security is so far advanced from what we typically, or many people often think of, the security guard that's sitting outside a store monitoring and providing a modicum of security there. They're very advanced, very well trained. I won't get into naming different companies, but they bring a lot of capacity at lower cost and can be a meaningful complement to the public police with its more finite and high cost resources.
Thank you. Do others have thoughts on this question? Okay, Mr. Lindsay, I have a question that I think you're well positioned to answer here. So, but others are free to jump in as well. So one of the agencies that we haven't talked about is the Canadian Armed Forces. And so under our model of emergency management, provinces can make requests for assistance to the federal government. And I think we have a bit of a pattern now of when those requests for assistance come in, it's often the military that responds, whether it was during COVID and staffing long-term care homes or during floods or wildfires. Are there other models that we should be exploring rather than sort of assuming that the military is going to be there to fill these requests and is well positioned to fill these requests when they come in? Are there alternate models that we should be thinking of?
Yes. First of all, I think the question of whether the military is well suited to some of the jobs is debatable. The fact that when a community is facing emergency, that their local resources and capabilities have been exceeded, we need to look to where we have extra capability. And within the federal government, the armed forces are a large, trained human resource. and they have some equipment that's appropriate to get into rough terrain or other things. But we could be doing much of the same work if we were working with community groups or others without, as you've suggested, just assuming that when things get too bad, we'll turn to the armed forces. And I believe in the media recently, there have been discussions about the fact that that's not also what the military would like to see its role as. Having said that, other countries do have other citizen preparedness models that engage more of the citizens into that task. The other challenge is that we now face, compared to, say, 1950, when the Army came into Winnipeg to help with the flood, or when Mel Lastman asked for the Army, we now have to face the workplace health and safety issues. We can't send a soldier to do a task like sandbagging if they haven't been properly trained to do that, or if they don't have the proper safety equipment. And we face the same thing with volunteers. So one of the underlying questions, I think, is that are the special powers that the provinces and the federal government have claimed in times of emergency, are they really the powers that we need? Or should we be able to, in a state of emergency, say, we are suspending some aspect of the privacy legislation, or are we suspending some aspect of workplace health and safety, recognizing that volunteers are going to be working in a dangerous situation, which is the entire community? So it's about having more tools than just that hammer, that we're always looking to use those extraordinary powers. Extraordinary powers that we felt were inappropriate even in the Second World War when we used them. And they're still the same powers that we have on the books today. So I do feel there's a lot more that can be done within the emergency management community to offer more alternatives.
Thank you. Do others have thoughts on that question around the role of the military in responding to provincial requests for assistance? President Sayers.
Yes, in some of the fires in 2017 in BC, First Nations were asked to leave their communities and homes, and they refused. And, like the military, who's trained to be doing this? And so I guess that's my question, is how can we better prepare in our communities for these emergencies? Because as was stated, the military is not always the best option. And if we're going to be using the military in some situations, I think that's another area that there could be protocols between governments, First Nations, on how that happens, and that within the lands of the First Nations, of course, they should be the people managing the emergency. So, I think we really do need to be looking at better ways of preparing ourselves for emergencies, capacity building, equipment, etc., as opposed to, the military would be something, but maybe it'd be further down the line if we can actually find local help.
Thank you. Okay, Commissioner, do you have other questions or clarifications?
No, I think it was a excellent panel. We have another question here. Hang on.
Sorry, Cal. You get the last word.
Thank you, and I apologize, Commissioner. I was just reflecting on the last question asked in terms of some of the specific duties that private security could attend to, and I thought it might be useful to whoever the questioner was to give a bit of a sense of some of those low risk to harm duties, what they might be. And I think they could range from on-site detention processing. So this is something that's common in some jurisdictions in the UK. It allows police officers to be at the front line, and whether it's taking control and custody of people, either to be taken to hospitals or to detention facilities, that's a role that the private sector can play. Manning barricades has been discussed. Patrolling other parts of a city while the public police are busy with a public emergency. Traffic control, and there I'm speaking about the lower risk ends of traffic control. Crowd control in nonviolent aspects of a protest. So there's been discussion certainly yesterday in terms of alternative sites where those with legitimate purposes may wish to go. There's an opportunity there to engage the private sector in support of that. Crime scene protection is another very common role that they can take on, as well as support in the forensic identification side, photography and those types of things on site. That's not exhaustive, but gives a bit of a range of scope, if that helps. Thank you.
Yeah, thank you for those examples. All right.
Okay, so I'll, not seeing any more hands, I'm going to now thank my panelists, and in particular, I thank those who have come from afar to participate, Professor Newman from England and President Sayers from the West. So thank you all for joining in this very interesting panel. Ce fut un grand plaisir de...
It was a great pleasure to listen to what you had to say, to hear your thoughts, your considerations, the ideas that you put forward. I greatly appreciate this on behalf of the Commission, and I think that we do need your support, people like you, in order to have a brainstorming session to find new concepts and to better understand the issues facing the Commission and basically the Canadian society.
For all the thoughts and contributions. And in particular, thank you for presiding over the group, Jocelyn. That was, I'm sure there was a lot of background work that went into this, and also from the members, I'm sure, and that's very appreciated. So with my thanks, we're going to adjourn for the day and resume tomorrow morning at 9:30. Thank you.
The commission is adjourned. La commission est ajournée.